Go ahead. All right, welcome everyone. It is Wednesday, March 20th, 2019. Welcome to spring. Hope everybody is enjoying the weather outside. We've got a full agenda tonight, so we want to get started pretty quickly. The first item is one that's sort of been on the radar, at least for me, for quite some time, and that's prospective use of tax allocation district mechanism here in Athens-Clarke County. It's a system that you might be familiar with from some other places. Atlanta's used it in about a dozen instances, and many other cities throughout the state. Rome and Gainesville and others have used this tool to stimulate economic development in a way that can also provide for some more sort of holistic care for a corridor or an area, and also kickstart some of the other things we've talked about, like mixed income housing. So we're really lucky. Dan McRae, an attorney with Seyfarth Shaw LLP, is with us tonight, and he's done a lot of this work throughout the state and in Atlanta as well. So I'm going to call Dan up, and oh, there he is, and he is going to kick it off, and then we have some conversation afterwards.
How do I get this started? Enter's always good.
Oh, all right.
And there's my arrow. Okay, good. Hello, everybody. I'm Dan McRae. I am a lawyer. Please don't hold that against me. I do economic development and community development and redevelopment work, and I've been doing it for over 40 years. And I've done a lot of development district work. Development districts are a way of making growth pay for itself, and it's a way of getting things done sometimes that you can't get done any other way. I've actually got an all-day program coming up in Atlanta called Ask Me Anything about development districts and public-private partnerships and so on. You're all invited, but if you can't make it to Atlanta, and a lot of people don't want to, ask me anything tonight. So I'm going to try to go through this PowerPoint in 30 minutes, but that includes your questions. So as a thought occurs to you, please don't wait, just ask away. But with that, we'll get started. So what is a TAD? I learned not to assume that folks know what a TAD is. TAD stands for Tax Allocation District. Out of the states in the United States, 49 states have something like this, and every single one of them, other than Georgia, call it tax increment financing. So everywhere but Georgia, you have a TIF district. Here we have a TAD district. A TAD is not a thing. It's an area within which the city has additional powers, and you have to go through a process to get those powers, and we'll cover that in a minute. But the basic concept behind it is that you use the growth in property taxes, called the positive tax increment, and you spend that money in the district. So this is I'm much better at, data visualization is a hobby of mine. This is an area chart, and I can do much better today. But what this is trying to tell you is that in area one is the revenue that you've got now. You keep that. You, the public body, keep that. The growth that the TAD fund investment in the district is supposed to create is 2. That's your positive increment. That money is spent in the district. And then when the TAD burns off, when the redevelopment costs are paid, the local government gets all of the money, and that's number 3. That period of time represented on the chart is 25 years. The period is not set. You issue bonds representing the development costs. Those bonds get paid off with a stated maturity, and that's your term. But basically, a TAD is all about you figure out what you're going to spend money on. When you spend your money, the TAD is over. Why do you need a TAD? So ULI is an Urban Land Institute. I've got a lot of respect for ULI. They're smart folks, and they're in the business. So they think that it can generate enough money to make a difference, and you need to put the right safeguards in place. But the idea is, and the Redevelopment Powers Law, which in Georgia is the basis for this, says that the goal is to create a partnership between the public sector and the private sector where each leverages the other's advantages. I kind of like these quotes, Without something like a TIF or a TAD, the only redevelopment will be for the rich by the rich. And the idea is that you put your money where your mouth is. The private sector comes up and says, I would like to get some help, and we say, put your money where your mouth is, and we'll put some money into. That's the way it's supposed to work. This is a high-level analysis of why communities use TADs. First of all, you're looking in many cases at underdeveloped commercial corridors where you have high infrastructure costs, and an area that's not doing well typically doesn't have high infrastructure development, and that means that there's a sunk cost that has to be paid before you can basically fix things enough so that you actually have commerce and industry willing to locate there. New town centers, redeveloping downtowns, or revitalizing other areas, I do a lot of that. TADs are very active now in Georgia, now that we're out of the Great Recession, pretty much. You can't, a lot of those communities, remember the phrase positive tax increment I used a minute ago? Most everybody had a negative tax increment. You can't do anything with negative money. But now that commerce is back and money is changing hands, a lot of communities are taking advantage of it to fix up their downtowns or to create them in the first place. And then multiple objectives, there's a few. Mixed-use projects are typical, highest and best use, putting parts of town into service that are not in service. Connectivity is big, but I mean, TADs, what you can do with a TAD legally is defined by the law. But what is done and should be done with a TAD is intended to fit local circumstances. So really every TAD is unique. Basics. This is what the law says. You got to be an urbanized area or served by sewer. This was House Bill 69 from, God, how many years ago has that been? I don't know. The provision of the law about using educational taxes was declared unconstitutional. We had to have a referendum in Georgia, and then the law got rewritten. And to prevent overuse of TADs, Earl Earhart out of Cobb County got these provisions written into the law. So first of all, you got to be urbanized or served by sewer. Congratulations, Athens, you are. And the specific site has to be blighted or distressed, deteriorating, or an area with inadequate infrastructure. Those terms are defined in the law, but they pretty much mean what the phrase says. Two general types of TADs, and here's where we're getting into some useful information. So a project TAD, we've had TADs in Georgia for a long time, but if I were to ask, somebody walking down Peachtree Street, give me an example of a project TAD, they would say Atlantic Station. That's exactly right. So that was developer initiated by developer Jim Jacoby. An area TAD is like something that we helped Macon, Georgia do. They created a TAD and then ignored it, and so it never did anything. We actually had to dissolve it in order to create 3 new TADs there, including one on 2nd Street. I don't know if y'all know Macon, but it's not the main drag, but it leads to the main drag. So there was no particular project, no windfall of investment going to happen, just the idea that this whole area centered around 2nd Street is never going to get anywhere unless we give it some help. So that was an area TAD. Developers are the ones that typically bring you a project TAD because they've got the projects. Local governments are the ones that usually initiate the area TADs because they're looking at the broader picture. How do I do that? These are the steps. You get a local act. Anybody here a current or former member of the General Assembly? There's a lot of guys in suits back there. You sure you're not in the General Assembly? All right, well, so I can pick on them. So the General Assembly largely wants to control things. So in order to have a local government get access to redevelopment powers, which includes TADs, they insist on an act of the General Assembly being passed, which means if you don't have that local act and you miss the session, you got to wait a year before you can do anything. Then there is a requirement for a referendum. Athens did both of those things in 2006, so you're in good shape there. You need a redevelopment agency, which is the one that carries the ball. That can be you, that can be the commission, or it can be, well, I've got a list of the choices. I'll show you those in a minute. But you got to have a redevelopment agency, and it's the one that carries the redevelopment plan to the local government for approval. So the agency shows up one day and says, Commission, I've got a redevelopment plan I'd like for you to consider. That starts the process. So you have to have a notice Within a 60-day period, you've got to have a public hearing. So not another referendum, you've already done that, but you've got to have a public hearing. In order to tap the school district's increment, they need to consent somewhere along the way, not at the beginning, and sometimes they consent after the TAD's been set up and been in business for a while. I represent the DDA in Doraville, and the GM redevelopment was, and the CID bonds, those were the first community improvement district bonds ever issued in the state of Georgia, and that was all driven by the fact that we couldn't get the school board to consent. The county finally did, but for a while it was the city by itself. We found other ways to do it, but and there was some TAD revenues, but there wasn't any educational increment. So you do another ad after the hearing, and that says there's going to be a meeting of the commission to consider the redevelopment plan, and at that meeting the commissioners vote, not the public. It's important that in fact it's a requirement, that the commission determine that growth and development in the area of the TAD's hasn't occurred and won't occur in essence but for the redevelopment plan. I've never yet failed to qualify a district for a TAD or to find that but you got to do that. If that happens, then the TAD is created as of the end of the year in which the plan is adopted, or you can postpone it to December 31st of another year. By that date, you've got to apply to the Department of Revenue Commissioner to certify your return of the tax increment base. If you're dealing with increments, you've got to start somewhere. So this certification by the Revenue Commissioner is your number above which you've got money to work with. I get asked a lot, how long does the TAD continue? And most redevelopment plans have a date in it, but really it continues until it's terminated by the city, but the city can't terminate it until the redevelopment costs have been paid. As witnessed my Macon situation, if the TAD's not going anywhere, you could just declare, well, we've paid all the redevelopment costs we're going to pay, the TAD is done. But that's that magic moment when, and if everything's going according to plan, redevelopment has occurred, the tax digest has increased, public revenues have increased, you call off the TAD, and then suddenly all of those revenues go into your hands. So here's some misconceptions: that property taxes are not abated, they're not increased because of a TAD. Millage rates are not frozen within the TAD, but when you do your budget, you got to base it on what the base was. So you can't take into account growth. Your choices for who gets to carry the football, that can be you. And the next two bullet points, I'm a victim of search and replace in Microsoft Word. So the commission, by resolution of itself, it doesn't take two local governments, can create a new public body called a redevelopment agency. I represent the redevelopment agency of the city of Warner Robins, which is very active. It works hand in glove with the Downtown Development Authority and the Citywide Development Authority and the Urban Redevelopment Agency. Oh, there they are. So the URA, the city has a URA, can be the redevelopment agency for TAD purposes within the area where it's got its redevelopment plan approved. And Athens has approved a redevelopment plan for the URA. The DDA can be your redevelopment agency within the downtown area. So you can have more than one redevelopment agency. But it can be you, the city. It can be somebody new that you create. This is one of the, I'm not aware of another provision in Georgia law that lets you just create some brand new agency like this. But one way or another, early in the process, you've got to have one of these. Now, what can you spend your money on? So, redevelopment costs. And these are some examples. Take a minute and look at that. That's a pretty long list. One thing that should jump out at you is that in Georgia, and Georgia's not the only state, but it's a minority of states in the country where you can take TAD revenues and spend them on private development costs. And it's a conception, it's a misconception though, that TAD revenues can only be spent on public infrastructure. That's what they're mostly spent on, but not entirely spent on. The city of Atlanta the city of Atlanta has created so many TADs that they can't create anymore. They've committed 10% of their tax digest, so it's game over for them until they can terminate a TAD. The Mayor Cassim tried to do that, and council wouldn't go along with it. So right now, they've got all the TADs they're going to have. But what this means is that if you have usually a project TAD, and the developer comes to you and says, this project is not going to work. I've either got to increase the revenues, and if I do that, the project's not going to work because nobody will come in and rent or buy from me, or my costs have to go down. And what I'd like to get from you, the city, is a grant. And the statute lets you do that in Georgia. The Constitution says you may not, public sector, confer a gift or gratuity on the private sector. It's unconstitutional. Unconstitutional is the same as illegal. You can't do that. But we do have grants in this state. The state makes grants, and you can do it in a proper way where you're getting equivalent public benefit back in exchange for your money. You don't have to trade a dollar for a dollar, but you can trade a dollar for executing this plan, creating this number of jobs, generating this number of revenues. I've done some work in Albany with their tax allocation district, where we have committed subordinated loans, land, where the payback by the developer is that over a period of time, he will pay taxes into the special fund, the TAD special fund, at least equal to the subsidy he got from the city. And if he doesn't deposit those many taxes, he has to pay a clawback payment. So there needs to be checks and balances in this. But in Georgia, if you go about it right, you can pay a portion of private redevelopment costs. So anybody got any idea what that portion ought to be? Somebody throw out a number. You can do whatever you want to, as long as you can justify it under the constitutional test. The range is usually 13 to 15% of the total project costs, but remember, every project is different. If somebody makes a case, then listen to the case. If they don't make a case, don't listen to them. Some of the other things that you can do with TAD money is public or private housing. Generally speaking, residential is not a local government function. It's not a development authority function. It's not your governmental mission, but this is one instance where the General Assembly has conferred housing powers, not on the housing authority, but on the city. And these are the other examples that you might run into in the course of administering a TAD. And TADs do have to be administered. Gainesville was mentioned earlier. I've done some work with Gainesville and their tax allocation districts, and they are known throughout the state for having a well-administered program. Some more examples of redevelopment costs. These are, it's what you would expect. Basically, it's difficult to find something in Georgia that you can't spend money on, a type of expenditure, but always it's got to accomplish redevelopment. That's what this act is about. How are they paid? Well, the tax commissioner sends you the money and you put it in a special fund, and then where does it go from there? It doesn't do any good if it stays in a special fund. So there's two ways you can invest that money. You can invest it pay as you go, meaning as the collections come in, when there's money in the pot, you can spend that money. That's not as powerful an incentive to a developer as it is when you monetize those TAD revenues with tax allocation bonds. That's forward funding. So the opposite of pay as you go is pay as you use. It doesn't put you out of the game always if your TAD program is pay as you go, because if the program is solid enough, and if it's particularly if the TAD's got a history, the developer can go to his bank and say, I have this additional source of income. Here are projections. You can count on this money coming in just like you can count on the rents from the project coming in. And I want you, Mr. Banker, to increase the amount of the loan that you're making me from our project. So that is a way that you can get upfront money for a redevelopment project in a tax allocation district without the city issuing bonds. The city is the bond issuer, incidentally. They are revenue bonds. There's no referendum. There's no general obligation of the local government, but they are city bonds. An advantage of the pay-as-you-go system is it's really kind of performance-based. If the developer doesn't do what he said he was going to do, there's not going to be any money, so he doesn't get any money. So that's kind of a self-regulatory aspect of that. But whether it's pay-as-you-go or pay-as-you-use, you do need a development agreement or a memorandum of understanding for, it's for one thing, it's good business. For another, you need it for the constitutional test. Sources for repayment of TAD bonds: positive tax increment, lease or contract payments from the district. This comes up sometimes. Local governments usually don't like to tap the general fund. So I mentioned the special fund, right? That's where your increment goes. If you can dip into your general funds, the funds that the city has that are not earmarked, and you can commit those funds from the district to pay redevelopment costs if you want to. There's a statute that says specifically if you're doing tax allocation bonds and you determine that the tax increment's not going to be sufficient to pay those bonds, you can then pledge the general fund revenues to the repayment of those bonds. And there's some examples: all property taxes, the share of the local option sales tax, business license fees, hotel motel taxes. Most local governments don't like to do that. Again, it depends on the case being made. It's rare in this state that that's done, but it is possible. And then, bonds have reserve funds that after a while become available because you're in the last year of the bond period. Y'all aren't asking any questions.
All makes sense.
Okay. Think of any, let me know. Special features of TAD bonds, and this is kind of, I do bonds, so I just can't resist throwing some bond stuff in here. It's important to a bond investor where he stands in the food chain. He wants to get paid first. Well, that you can have a security deed, and then you have a first mortgage. But on top of the first mortgage, or prior to or senior to the first mortgage, is taxes. If that bond investor is investing in TAD bonds, his revenue has lien status. It comes before the mortgage, and that's very important. Optional backup assessment. What if the developer doesn't perform? He doesn't perform on time. He doesn't perform to the level that the bond model was based on. There's a way to hedge that bet by creating a special service district, a special tax district that says basically, if the regular taxes aren't enough, we're just going to tax you enough to get the money that it takes to pay these bonds. Even though the city's not liable for the TAD bonds, it's an article of faith with bond lawyers that bonds must be paid. So this special service district backup is done. Atlantic Station actually had one. The Dorville CID bonds for the assembly project, the old GM site, actually had a backup assessment too.
How often do those have to be enforced to actually be used?
I'm not aware of a case in Georgia where it has had to be done, but it is a common feature of these deals. It's almost essential in order to have somebody buy these bonds because they're not going to be rated. You're going to have unrated bonds. There's a limited market, and these guys know the system. That's what they do, so that's what they're looking for. Can't blame them. TAD benefits. What does a TAD do for you? Bullet point number 1 basically says you can create an economic development project out of a site that's not right now. You can pay for economic development without raising taxes. You don't lose your existing tax base. You promote growth. You create jobs. All those things are true if you do it right. If you do it stupid, none of these things will happen. If you do it right, all of these things will happen. Something important to know. It's not geo debt. Doesn't affect your credit rating if used prudently. Now, but remember, these bonds have your name on it, and there's a lot of investment banks and rating agencies that don't like to have their bonds not get paid. So you don't want to overdo it. I think I say in a later slide, these TAD bond models are very, very conservative. Almost always the TAD bonds get paid off early. Camp Creek in East Point is one of the leading TAD success stories, and their bonds got paid off years early. These last couple of, I mentioned the last bullet point before, but the halo effect, this is often talked about with TAD deals. So you've got an area that's not doing anything. And it can be said that it's holding other areas back. You make nothing into something, and then the surrounding areas that aren't in the TAD, where those revenues aren't getting diverted to the special fund, also start doing well. And that's just good all around. What you need to tweaking TADs. You might need some seed money, be sure that you can afford it. TADs cause growth. That's a high-class problem most places, but I drive in Atlanta traffic, so it's not, in some places it's just a problem. But it can create additional demands for public services. But in my view, this last bullet point here is the most important, because if you overdo it, instead of money going into the general fund, the money's going into the special fund, and it's got to be spent in the district. It can't be spent anywhere else. California overdid it to the point where their legislature abolished all their development district entities, just abolished them, and that created a mess. Now they're retreating from that, because you really do have to have an entity that can do this sort of financing, and they're allowing it almost on a case-by-case basis. But it got to the point that so much of the public revenues of the local governments in California were getting gobbled up by TIFs. It became such a problem that the state got rid of them. And another example closer to home, and I don't want to talk out of school, is you look at a map of where the tax allocation district is in Doraville, where that GM site is, it's most of the usable land in the city. So that's great for the assembly redevelopment. It's not so great for the rest of Doraville. Execution risk, what happens if you lose your private sector partner halfway through the deal? You got to go find another one. Default, if you don't get sued on it, you don't, the bonds aren't getting paid, the TAD investors are foreclosing or at least exercising their remedies. So that's a problem for your project. And this is what I mentioned before. It's essential that these financial models be conservative. You don't want your name in the paper because people don't understand, It says Athens Tax Allocation District number 1 bonds in default. That's not good. You don't want that to happen. What safeguards do I need? I'm a lawyer. I believe in lengthy contracts. So have a development agreement with your private sector partner and cover these things there. That's your accountability. He's not going to walk up and say, hey, I'm not asking you for any money, but I want to commit to all these things you can sue me for if they don't happen. So if the way you get control over what happens is to put some money on the table, and the way you justify that is to bargain for this accountability. Make sure your redevelopment plan is right. A lot of these redevelopment plans are just cookie cutters. I've written them myself, and the ones we write are very specific to the situation with a lot of input from the private sector and from the public sector. We just got tax allocation district approved in Statesboro for a soccer stadium-based development, it's a mixed-use development. What really put it over the top was it was bringing a regional grocery store as part of it. Folks in the community, they wanted the grocery store. They didn't care that much about the soccer stadium, so it was going to be, that TAD would have been taken away if the grocery store did not announce by the end of last year, and it did. You control the money. The money goes to the local government. You control the special fund. And then, there's this no TAD to excess provision. You can't go over 10% of your tax digest with TADs. So, conclusion, it's like TADs are a tool. Use it wisely and you'll get good results. There are ways to avoid problems. Experience is the best teacher, but it's also the most painful. So make your decisions based on other folks' experience. Don't have those experiences yourself. What else can I tell you?
So y'all, there certainly some areas I've suggested kind of for use of this, but one of the things that I want us to do as a body in the near term is memorialize some goals for use of TADs, and certainly I've got some in mind that include mixed income housing development, generation of high wage employment, aesthetic improvements, kind of all modes of connectivity, and public spaces. So be interested in hearing, if some of those have particular interest for you, if there are some others you have in mind too.
I have a question. One of the requirements was that there must be access to sewer or an area presently served by sewer. Could part of one of the improvements made with the TAD also be expanding that sewer? Like, say you have a corridor with sewer along it and you want a mixed income housing development, and the TAD
more
could help.
capacity.
Yeah.
What a good question, because my Statesboro project had exactly that situation. It was served by low diameter sewer, and so that was inadequate infrastructure, which was one of the other tongs or throngs or whatever it is, prongs in the requirements to qualify as a TAD. But as an alternative to sewer, being an urbanized area satisfies it. Statesboro is not urbanized, according to the Bureau of the Census, but Athens is, so we don't have to worry about that. But I am kind of proud of my low diameter sewer solution. Yes, sir.
And can TADs be used in opportunity zones?
Oh, absolutely. Please come to my Ask Me. Are you talking about a federal or a state opportunity?
State.
Well, yes,
We
of
don't have
course.
any federal ones here yet.
Well, there are none at all?
No, oddly.
Well, you got to get the federal law changed, and good luck on that.
We're going to be working on it. See.
I sincerely wish you luck. I mean, there's tons of money flowing into those OZs, the federal OZs. But one of the things, and this is a federal opportunity zone comment, but it applies to a state opportunity zone too. What that is layering incentives, and you can never have enough incentives. The more, the better, particularly when it's a state incentive that doesn't cost the city anything. So an OZ is a state or federal OZ is a great incentive.
Oh, I was going to ask you, Kelly, if you have any like sites in mind yet, or like geographical locations you'd be interested to use.
I do indeed. Interesting that you asked.
Interestingly enough.
So I would say, I'd say there are a lot of prospective sites in
Yeah.
town, and I might ask Dan to talk about this one element in a couple of minutes. But, in my observation of county and municipal use of TADs in Georgia, there's sort of two approaches. There's the approach where it's certain or near certain that there's going to be some pending development, at least in part of a zone. And then there's sort of that field of dreams approach, where, we've got an area that we're not happy with, and we'll draw a box around it and call it a TAD and hope some folks come to the table. We've got one of the former. We've got several of the latter, the sort of field of dreams, but we've got certainly one of the former, and that really is that neck of Chase and Barber and Newton Bridge, where there are two pending developments kind of within what could, in my mind, be a great TAD zone, where we could get a lot of those goals that I mentioned earlier, better connectivity, bike, ped, and vehicular. You could get people from neighborhoods that really have no access to amenities, easily to amenities with any of those modes, lots of new employment, and lots of aesthetic improvements. So what I'd like to do is kick off our TAD program this calendar year with that zone, given that we've got both that general time area and the creature comforts expansion area on the table right now.
First TAD has to be a success. That's very important.
And Dan, I don't know if you want to talk a little bit about kind of your observation of that kind of pair of approaches, the field of dreams versus the bird in hand.
Well, I never turned down a bird in hand. But as I was saying earlier, it's the role of the public sector to take the bigger picture into account. And if an area needs something, or if the city as a whole will benefit from an area getting something, you have to look at it on an area basis. And going back, I'll make an example. They did and did nothing for years, and it took a more focused look at it. We're going to do these specific things. We think we can get this money for it, and it'll have this result, and that'll let us do more things. So a true field of dreams only works in the movies, but area TADs do work.
Is there any way we could, any recourse we might have in using a TAD and specifying, let's say you said you want to bring new jobs, but could we potentially target demographics we know or have higher rates of unemployment?
I think that's kind of one of those things that we absolutely could do. You know, another thing we can do kind of in partnership with tenants within a TAD zone is say that, you know, the higher the wages kind of within your project, kind of the more likely we are to play ball. Because that's what we're trying to incentivize.
Atlanta's also used TAD grants for affordable housing projects.
Yeah.
How you're talking about like with the wage setting, that has that been done other places where they've put those
Dan's probably more familiar.
goalposts for wage? Yeah.
You see, it's uneven. It's uneven around the state, but it depends on the city's objectives. Back in the good old days when almost literally there was a line of developers going out the door of Invest Atlanta because the city was handing out so many TAD grants. But they all had development agreements and they all committed to do certain things. You have to be targeted about it, and you have to be aware of, you know, federal laws in particular that you don't want to violate when you're when you're targeting who your beneficiaries are going to be. But subject to that, yes, I mean you can. The whole purpose of an incentive is to incent behavior. So if you can, if there's a legal way to do it, whatever you want to do, I bet you I can find a legal way to do it. But it's got to work in the business world, or the developer won't do it because he'll go bust.
Sure.
I'm sorry I got in late, closing down the shop, but what is a TAD grant?
Let me just zip back here. Gosh, I love my PowerPoint. You look at the top bullet point here. So TAD revenues can be used to pay redevelopment costs, including costs for construction costs. And then you go down to the second bullet point, and you can find a bunch of other things. Look at the first indent under the second bullet point. For use in any business, commercial, industrial, skip governmental, educational, charitable, or social activity. That basically says you can spend your money on anything, and you can spend that money by paying the redevelopment costs incurred by a private developer. It has to be by contract. You have to honor the prohibition on gifts and gratuities in the Georgia Constitution. But you can call it a grant. But it's got to be a grant with strings tied to it. It can't be free money unaccountable.
Thanks.
Any other questions?
And I guess just on the redevelopment plans, I mean, that has to be created per district, right? So if we were to.
Yes.
Okay.
Yes, it sure does. And there's the statute has a list of things that have to be in it. It's not hard to, I mean, you have to be thorough, but it's not hard to do one.
All right, again, just in terms of next steps, I'll be asking this body to kind of memorialize some goals for use of this mechanism, and then shortly thereafter, draw a map and begin the sort of more granular work on the district. And I think because we've got a real enormous opportunity with our first one, you know, that'll get us out of the gate successfully, and then we'll be able to employ this in some other places throughout town as appropriate. So excited about this and excited about for the community more than anything. Dan, I can't thank you enough. I appreciate you coming out.
It is a great opportunity. It's been a long time since 2006. It's time to put this tool to work. But I really have enjoyed being here tonight. If y'all have follow-up questions, please feel free to ask. And I'm serious about the invite to the Ask Me Anything in Atlanta. I'll send you guys invitations, so if you want information, they'll have it. Well, thank you for having me tonight.
Thanks so much.
Thank you.
Thanks so much. There's no traffic getting too bad on the way. It's okay.
Suki's en route from another meeting she's been at. We're going to let TJ go on and go ahead, especially with all our guests here.
Is that why it says pros?
I wasn't going to point that out, but yes.
But was no one going to be for the River District?
Y'all, as TJ gets set up,
That guy.
just want to thank everybody from the criminal justice system broadly for spending some time with us tonight. Quite a few folks here from various branches and offices.
Great job, Ransom.
Of course, one of our kind of most significant budget goals was some evolution of criminal justice system work, and so TJ is going to be able to provide us sort of a high-flying overview, little historical snapshot of what we've seen locally and on the state level over the last decade or maybe slightly longer, and then some feeder material for where we go from here. And then I know you might have questions for him and several of the other folks in the room too, kind of after that.
Allowing questions tonight.
No, TJ says no questions tonight. He's just a one-way operation.
Yes.
So I'm surprised you didn't just port in video-wise.
Yes, yes.
Good to have you here. Thank you.
Well, thank you, Mayor. Again, for those of you who don't know me, I know commissioners that have been here before, so I'm certainly honored and privileged to be back before you. I won't be talking about a courthouse tonight. I'll be talking about what goes inside and goes on inside the courthouse. I'm TJ Bement. I'm the District Court Administrator for the 10th Judicial District. 10th Judicial District includes 6 different circuits in the northeast part of the state, of which the Western Circuit, which is Athens-Clarke and Oconee, is one of the 6 circuits that I cover. I also go down to Augusta and over to Newton and Walton and up to Jackson and Barrow and Banks and various other places in between. One of my other roles that I've had the privilege over the last several years is I've been a member of the Council on Criminal Justice Reform that was started about 8 years ago under Governor Deal. I came in about the second year of that council and was privileged to be part of that process, led largely by Justice Boggs and then the various councils that serve the governor's office. We had a variety of folks that served on that council over the years, including legislators, public defenders, district attorneys, solicitors, attorneys, and a variety of other folks. So over the years, we have dealt with criminal justice reform issues in the state of Georgia. Today, I'm going to go through that a little bit and give you a quick background of both some civil and criminal justice reform history, both here locally and at the state level, and then sort of close out with sort of what some of the next steps are with some help from Judge Hope, who has been leading some of our criminal justice partnership discussions. So to get rolling, to put it in a little bit of context, criminal justice, at least in the Athens area, is not a new thing. Going all the way back to 2003 was the first time that from a system-wide perspective, we looked at criminal justice issues in Athens. The primary driver back then was the jail and the size of the jail at the time. We were looking based on original forecast then. Back in 2001, the jail had about 380 or so folks in it, and it was projected by 2016, which is actually 3 years ago now, to be almost 800 individuals in the jail. That was assuming, of course, that no criminal justice reform efforts were done. And I'm going to go through what some of the things that have been done that have kept some of our jail numbers down. Beyond that, looking just a couple years in advance, they were looking that by 2021, we would need 950 beds in the jail, again, assuming no changes in our criminal justice process. So we brought the folks in from Carter Goebel Associates and the National Center for State Courts to look at this. They did an inventory of our criminal justice system, looked at that workload of capacity, came up with those projections, and then made some initial recommendations for us. Those included creating a pretrial release program, expanding our drug court, establishing a mental health court, establishing a diversion center, remodeling and expanding the jail, and doing some improvement efforts in coordination of the efforts that we were doing at the criminal justice. So that was in 2003. We started some of those efforts, but we weren't done. So fast forward 5 years later, we brought the folks from Carter Goebel back again to take a look at what we were doing and what our success had been so far. Again, they evaluated the needs and the capacity of the jail, projected some new numbers based on some of the efforts that we had made, took a look at our criminal justice system again and the efforts that were going on, especially with regards to diversion, and made some additional recommendations for new programs, costs for those impacts on that with regards to the jail population, and again, rounded out with some improvement strategies. So what did that mean? Again, reestablish a pretrial release program. that we hadn't really picked up yet from the 2003 recommendation, implement the mental health court that had not fully started yet, continues various improvements, do the jail expansion and remodel, which for those of you who remember became the large project on the 2009 SPLOST, and then develop a judicial outpost that was putting a hearing component over at the jail for our judges to use, develop a diversion center, which also went into that later SPLOST, and continue some of the improvement efforts that we were making locally. So while this was going on around 2008, early 2009, 2010, the state had some issues that it was facing as well. Much like Athens, they were looking at a prison population that was expected to increase. They were expected over the next few years, we had been looking at a 35% growth up to 2011 over a 20-year period in our state prison system. We had a significant number of folks at the Georgia level that were in prison compared to the national average. And we were looking at a state prison system that was overpopulated to the point that we were looking to have to build at least one new state prison, possibly two state prisons, at the cost of hundreds of millions of dollars to the taxpayers. And that was looking to increase our population at the state level of 60,000 prisoners and a ticket item of about 264 million. Also looking at some of those numbers, about 60% of new admissions into the state prison system were folks for drug-related offenses. So that's what the state was facing at the time. That entered the process of criminal justice reform here in Georgia. So looking back there at 2011, you'll see in the top left, that was that 52,000. At that straight line projection based on history over the last couple of years, going up to 2006, we were looking to have that population of nearly 60,000. You can see the actual numbers that have been going into our state prison system starting in 2011 when the state started to implement some of its criminal justice reform efforts. And right now, we're somewhere around 53, 54,000 folks in the state prison system. I'm going to go through that a little bit more here. So again, looking at those numbers back in 2010, significant numbers of that 50-some thousand folks, 5,000 were low-risk drug and property offenders in the Department of Corrections, which was a quarter of their admissions in 2010. We also ranked one of the lowest in the states compared to all our colleagues around the United States in the number of folks that were under some form of correctional supervision. That is a broad term that includes folks in prison, but also people in jail and anyone under some type of supervision. That included misdemeanor probation supervision, as well as felony supervision, or any type of bond supervision at that time. So while it was 1 in 31 was the national average, in Georgia we were 1 in 13. So you can look around the room and do the numbers. In this room, you'd be looking at 3 or 4 people that would be under some form of correctional supervision based on the average in 2010 in Georgia. So to kind of give you a little history here, going back all the way to 1991 on a couple of things that the county and the state have been involved in. Mr. Malden, who's back here, was one of the first folks in the state of Georgia to create a victim assistance program as part of the prosecutor's office that he created back in 1991. He was also one of the first ones in 1991 under the statutory authority that the General Assembly gave to create a pretrial intervention and diversion program. These are folks that the prosecutor's office reaches out to, and based on the low-level offense, or maybe they're a newcomer into the criminal justice system, gives them the opportunity to basically stay out of trouble for a period of time, at the conclusion of which usually their case will be dismissed or null prost. That state law was back in the early 90s, and Athens was one of the first ones to implement a program that still runs quite strong today. Fast forward a few years into 1998, the Western Circuit was one of the first ones to create a domestic violence task force. That's a program involving not just law enforcement and the prosecutor's offices, but also working with other law enforcement in the surrounding communities to address domestic violence issues. Fast forward to 2001, we created a special victims unit as a program within the police department, as well as with the prosecutors, to have special individuals that investigated sex crimes and violence against women crimes that in the area. Again, 2001, the DUI court that was created by Kent Lawrence at the time. This is again prior to that Carter-Goebel study. We were one of the first jurisdictions in the state to have a misdemeanor DUI court program. Then you see in 2003, that first Carter-Goebel assessment report. Then 2 years later, we created our felony drug court. This is a drug court program for felony-based offenders who have drug and alcohol offenses that cause their underlying criminal activity. We created that as a direct recommendation of that 2003 Carter-Goebel assessment. Fast forward another year to Carter-Goebel in 2008. Then during that next SPLOST process, we opened the diversion center, which is down on Lexington Road, and I'll talk about that in a moment. We expanded our jail. We started that process in 2012. I've got a couple of dates here. 2008, probation services, misdemeanor probation services were created after the Carter-Goebel study in 2008, and we also created our mental health court. All is at least indirect relationships to those recommendations that came out of that report. So you'll see on those next two lines where you see the gold seals, that's where the state of Georgia picked up its criminal justice reform efforts. I'm going to walk through these really, really quickly just so that you can have a couple of the highlights of them. Looking back to the beginning there, in the 2012 session, where we looked at adult sentencing reform. As you remember those numbers that I showed you a moment ago, we had significant numbers of folks in the state prison system that were there on low-level drug offenses and property crimes. So some of the sentencing reform efforts that the state looked at was going to changing some of the threshold for burglary, theft, and forgery from a $500 limit to a $1,500, so that if you basically stole an iPhone back in 2011, that would have been a felony charge. So up the level of what those things are so that those kinds of smaller thefts do not become felonies anymore. We moved to weight-based sentencing on drug charges. We looked for electronic submission of sentences to the Department of Corrections, all things that got both cases moving, as well as tried to reduce some of the prison population in the state. We established some safety valves and whatnot within the criminal justice system, some truth in pleading in the process, created conditional driver's licenses for folks within our drug courts, and expanded some of the opportunities for folks that are nonviolent drug offenders to expand the parole eligibility so that they could get out of prison sooner. Going into 2013, we changed gears at the state level and looked at juvenile justice reform. This involved almost a complete rewrite of the juvenile code and a switch from thinking of children as delinquent offenders and moving them into the realm of thinking of calling them children in need of services. It started a rebirth or a relook at how we addressed our juvenile population, that we looked at them mostly on a basis of what services can we provide for them in the community, rather than what do we need to do to detain juveniles that are offending. That was the gist of that. Moving into 2013, we created our Veterans Treatment Court here. The state then moved into 2014 to adult reentry. This is a process of individuals leaving our state prison system. In the past, the process has basically been when your time is done in the state prison system, you're given that bus fare back home to where you came from, and a slap on the back and a thumbs up for good luck. That was the general extent of it. This created a new process where we focused a lot of effort at the state level on creating GED programs within the state prison system, creating other opportunities to make sure that individuals, when they were leaving prison, had, if not a driver's license, a state-approved ID, and had a copy of their birth certificate and their social security card, and were given some job and other type of reentry type assistance to meld back into the community when they were done. Moving back into 2015, the focus was on misdemeanor probation reform. This was in light of some of the issues going across the state, largely with some of the private-based probation companies and how perhaps they were charging a higher level of fees for supervision services and whatnot. Not an issue we had here in Athens. We had moved to a government-run probation office almost 7 years before. So out of this misdemeanor probation process included a mandated conversion process of converting fines to community service, presumption of indigency for folks that have left a jail or a prison, also allowed tolling of misdemeanor sentences so that people couldn't just be held on probation for extended periods of time if they failed to show up. And most importantly, established a pay-only process. Previously, we had a lot of folks in the state of Georgia that would be put on misdemeanor probation because they could not pay that traffic fine. So they would go on probation and have to pay a supervision fee of anywhere from between $30 and $50 a month while they were trying to pay down that $100 or $150 traffic offense. So you can do the math that folks went through 3 months, 6 months, 9 months, a year on probation without ever actually touching the underlying fine. So we established a process where supervision fees could not be charged for an initial period of time to allow folks to pay down that initial traffic. Also did some modification process with regards to incarceration for failure to pay, and changed a couple other statutes related to misdemeanor probation. Moving on to 2016 very quickly, it was criminal records and recidivist sentencing was the focus of our state efforts. The large process here was really looking at some of our sentencing practices and determine some ways that perhaps we could restrict criminal records, that folks got them expunged because certain time had passed on that misdemeanor, and in some cases that felony record, they could petition the courts to get those records removed. That is an effort that's still ongoing in a lot of jurisdictions. Some of that actually happened administratively with our Georgia Criminal Information System. That just happened by rote of law with some of the changes that came from that. Others had to be petitioned down to the local level. It also involved things with our First Offender Act. These are folks that are new into the criminal justice system, an early felony or first felony, restored some of the intent behind that law to make sure that folks had that full opportunity, not just at the felony level, but also at the misdemeanor level, that charge could be reduced and removed off their record at some point. We also looked at that year a couple of things with school disciplinary procedures. This was one that we had a big change, and I think it was also felt here locally in Athens. One of the changes that disruption of school is a misdemeanor offense. This was an offense that was largely charged against children in our school system. So if a youth, as I'm sure as Mayor Gertz is well aware back in the day, if a youth offended and disrupted school, you could very easily charge that youth with a misdemeanor offense and bring them into the juvenile court process. Some of this legal change said that was not the original intent of that law. That was meant to be outsiders that are interfering with the operation of a school. So it now required an internal disciplinary process be in place in every school district. Athens, again, was much farther along than a lot of jurisdictions in the state, making sure that was that internal disciplinary process prior to a child being arrested for that type of offense and placed into the juvenile justice system. We also had a lot of additional revenues that came in at that time for expansion of drug courts around the state. During this process, we moved from about $2.5 million in state funding for juvenile for accountability courts to this day, well over $30 million in state funds to support our accountability courts in about a 5-year period. So rolling on very quickly to felony probation reform, very quickly there, we had about 471,000 felony probationers in the state of Georgia. That's over 6,000 felony probationers per 100,000 residents. Anyone want to wager what the national average is per 100,000? I can tell you it's less than 6,000. It's about 1,560. So we had about 4 times the national average number of folks on felony probation at any given time. The reason being, we have folks on probation for drug offenses and other things for very, very long times. When we looked at our surrounding jurisdictions in the Southeast, most felony drug-related offenses, this is a violation of a Controlled Substance Act, so this is possession of marijuana, possession of cocaine, those kind of things, not distribution or trafficking, but just possession. That the standard probation term would usually be about 2 to 3 years. In the state of Georgia, it was 4 to 7, and sometimes higher. So some of the sentencing reform took a look at this to sort of contract some of those numbers. We also baked in part of the process, creating what's called a behavioral incentive date, meaning that at a certain point of time, 3 years out, there's a mandatory review of an individual's probation status at the felony level, and if they've done everything that they need to do, they either roll off of probation or they can put onto some type of low-level administrative status. It also sort of incentivized that process for folks to get things accomplished and addressed, paying back that restitution if need be, doing whatever other conditions that that was required to get that taken care of in those first couple of years. Then finally, in this last year, our effort turned to focus on misdemeanor bail reform. The main focus here was to give additional options for judges in the criminal justice system to address folks being arrested for misdemeanor offenses. This included allowing judges of any class of court to set bond. In the past, you would have somebody arrested perhaps for a city charge at a municipal court for something like a disorderly conduct or a criminal trespass, and they would be given a bond. But a magistrate judge in the county that that city laid in would not see that individual. They would see them at the local jail and say, okay, your city court will see you next week or 2 weeks from now when they have court. So that person would sit in jail waiting for that city judge to appear. Again, not an issue here in Athens. As part of unified government, our magistrates already were setting bond through an agreement with our municipal court, but that changed that practice to implement it on a statewide scale so that magistrates definitely have the authority to establish bond on those types of cases. We established a process of citations in lieu of arrest for misdemeanor offenses. Prior to this, the only state-based offenses that were allowed to be issued under citation were an underage possession of alcohol, and I'm vaguing on the other one, but the primary one was underage possession of alcohol. So it was expanded to include doing a citation for a marijuana less than an ounce, for shoplifting, for criminal trespass, refund fraud. That's when you go and sort of take something and try to get a refund as a result of it, as well as that underage possession of alcohol. So those are now citation offenses. That is a process that's currently under review by the state on how to establish and implement a citation-based system here in the state of Georgia.
Mr. Bement,
Yes.
are those, to what degree are those changes retroactive? People convicted of those crimes in the past, now the law's changed where the punishment is less or the record can be restricted?
Right. So if with regards to that sort of record restriction process, there is a look back. There is a look back on that process that allows a person to petition the court to look at certain offenses that have now been reduced to have those records reviewed and perhaps expunged. A good example at the felony level, Mr. Malden in his office looked at a handful of folks in the state prison system that had been incarcerated by an order for more than 10 years, at least according to the numbers at the Department of Corrections, that were there on a violation of the Controlled Substances Act, essentially a drug offense. So he and his colleagues around the state took a look at their cases to see, do those folks under today's changes in the law and the reduced sentences and whatnot, do those folks need to be looked at to perhaps modify their sentence? It turned out in a handful of cases that actually applied to. The folks here had done it right, and there were other issues involved, such as significant probation violations, significant other felony history, et cetera, that justified those lengthier sentences over 10 years. There was one case that wasn't on the list that Mr. Malden's office found anyway, and they did do a modification of that sentence to get that person eligible for parole sooner. So there is a look-back procedure for some of those as well. So again, rolling on here, and then lastly, on misdemeanor bail reform, a couple of things we looked at was to encourage the use of text reminders or some other type of court notification process to encourage folks to come into court, and allow some additional discretion for judges to include things like GED and other types of things to count towards community service in lieu of fines.
TJ?
Yes.
Does the practice that they're building here in Athens now of identifying a person who's having a mental health crisis and finding another way to help them rather than jail or the emergency room?
Yes, sir.
Do there need to be any changes or any reform to facilitate that kind of a process?
Yes, and if I could put a pin in that for just a moment, I'm going to go over some of the local efforts for the Justice Mental Health Collaboration Project. So I'm going to hold that for just a moment. So hold me to that if I don't cover it in depth. So just wrapping up, when we look back on the almost 8 years of criminal justice reform efforts at the state, and I can go ad nauseum into details, and I will spare you that process. We've expanded the amount of money available to our accountability courts, of which Athens-Clarke County receives about $500,000 plus a year in state funds for that. We've moved funds into the juvenile justice system as well for community-based treatment and services, again, which Athens has been a recipient of. We've created educational programs within the Department of Corrections. For the first time ever in the last couple of years, folks can leave the Department of Corrections, a state prison, not just with a GED, but with an actual high school diploma through a charter school program that is now partnered with the Department of Corrections as part of some of these reform efforts. and some additional funds for reentry services and the creation when the Department of Community Supervision was created. So again, here you can just real quickly look at the population in our county jails, going back to 2009 and carrying us all back through July of last year. Numbers are up and down, but you can see those green dotted lines. Those are some of the legislative efforts that came after each one of the reports that was issued as part of criminal justice reform. And after each one of them, most of our local jail populations dipped. Now, did they creep back up over time? Yes, that can be attributed just to growth and things of that nature, but largely the numbers of folks going into not just our prison system, but into our jail system have been decreasing as well. Here again is our prison population looking from 2012 to 2017. You saw that big spike at the beginning that was going to lead to those high numbers well over 60,000. So as of last summer, we had just over 53,000 folks in the state prison system. Again, you'll see the green dotted lines that indicate some of the criminal justice reform efforts and the changes in the population. Our number of commitments into the state prison system has gone down significantly. So while the number of folks in our state prison system and our jails is important, the number of new people going into incarceration at the jail level or at the prison level is probably even more important. So again, you'll see those criminal justice reform efforts. And since then, the number of new individuals going into our state prison system has decreased dramatically. What is that a result of? Largely, that's the decrease in those low-level drug and property offenders are generally not going into the state prison system. What does that mean? If you're not having low-level, low-risk individuals go into our prison system, that means the folks that are going into your prison system are the folks that are meaner and badder. And that's to be expected. So our prison system in the state of Georgia is becoming a much more hardened level, meaning the level of violent offenders in our state's prison system is more than it was in the past. And that is to be expected when you send the low-level offenders out into the community and divert them in the first place.
TJ, I was looking up on the Georgia Department of Corrections website, and they had just put out their annual statistical report for 2018. And that showed that right now for the statewide system, we are actually at 108.5% capacity for our state prisons.
We are still at capacity because when we started the process back in 2011, we were already over capacity, so we have not built new prisons rather. So they're still at capacity, but they have stemmed the need to have to build a new prison. So what the hope is that with that decreasing number of new folks coming into the system, plus some folks now getting parole eligibility sooner than they would, that there will become an equilibrium so that it's probably going to hover around 100% or so for the foreseeable future. But it's not going to be at the 110, 120% of capacity that it was projected to be. I can tell you the state of Georgia is going to be very hesitant to build no prison if they can do so. They can avoid that. One of the most important things that's come out of criminal justice reform is the change in the demographic makeup of our state prison system. For the first time since 1997, the number of African Americans entering the prison system in the state of Georgia has been its lowest. That's significant. So with the diversion of folks of those low-level property crimes and the low-level drug crimes into community-based treatment and other types of programs and not going to the state prison system, the number of new folks, especially African Americans, has been decreasing. Folks then ask the question, well, are we having an increase in crime if we're putting less people in the state prison system? And the answer is no. Both nationally and here in Georgia, the overall crime rate, both violent crime and property crime, is overall down. Meanwhile, the number of overall crime in Georgia has not been increasing, meaning that the criminal justice reform measures aren't just window dressing. We're not just doing window dressing, and meanwhile people are out recidivating and committing new crimes. The numbers are actually going down overall as a result. Also on the juvenile justice side, when we made those changes in the juvenile justice system, the whole point was to remove individuals, children, from the juvenile justice system, essentially from detention-based placement. While it may cost somewhere in the neighborhood of $10,000 to $20,000 to house an adult, it costs nearly $90,000 a year to house a juvenile in a secure detention facility. That is probably about 3/4 of the Department of Juvenile Justice's budget is housing juvenile offenders. We realized that we could do better, just like we were doing with adults, to divert children into community-based treatment systems. So the state pooled some of the money that was going out to state-based programs, reallocated them to the districts and jurisdictions that were in most need in the state of Georgia. Athens was one of them, to implement local community-based efforts to divert children out of a detention-based system. The goal initially was to do about a 15 to 20% reduction, and the result of that was significantly well beyond that, and that was not even with the entire state participating. So, very quickly, what are we doing here? I mentioned this earlier. Mr. Malden's office at the district attorney's level and Mr. Chisholm's office at the solicitor level have both been implementing pretrial release and diversion, pretrial intervention programs. Solicitor does about 400 of those cases a year. District attorney's office does about 45 cases of those cases a year. These are individuals that stay clean, stay out of trouble for about a year, and get their cases dismissed. Both of them have been participating in expungement and record restriction process. Mr. Chisholm has one coming up locally that the county's been involved in publicizing, and we're really excited to see some of that effort happen. Both of them have been actively involved in screening of cases for our accountability courts so that we can get the right participants in those. And of course, all the while, they've been providing services to victims. Our Superior Court has sort of led the charge with our felony-based programs for our drug courts, our treatment accountability court, that's the mental health court, our veterans court, and even our parental accountability court, which helps child support offenders. Our state court system does very quick turnaround on its misdemeanor cases, having walk-in calendars as well as weekly jail calls to move folks through their system as quickly as possible and get them before a judge so that they can get out of incarceration here at the local level as quickly as possible. And of course, they've been running the DUI court for a number of years, since 2001. Our magistrate court is available and operating 7 days a week hearing bond hearings. They are in the process of revising their bond schedule right now as a part of the process, as part of misdemeanor bail reform. That was a request made to all jurisdictions to review your bond schedule. And they're trying to connect folks with mental health issues to services at the earliest point of entry when they see them at that initial bond setting process. Juvenile court, as a result of that juvenile incentive program, has various community-based treatment programs like Thinking for Change to help the children in need of services. They also created the Athens Peer Court, which is for low-level juvenile offenders that are judged by their peers, meaning these are kids that play every role from the judge to the jury to the prosecutor to the defense that help represent children in minor status crimes. Address that at the community level. That's a partnership with the Fanning Institute. Has been very successful. It's now a model for other programs in the state, and we're very, very pleased with the effort in that partnership with UGA on that. Our municipal court, led by Judge Hope behind me, meets regularly with all our judges. He's now the chair of our criminal justice partnership, which we'll close with in a moment. He steps up and helps out in both state court, in our warrant program, and allows the other judges to make use of his courtroom because we have limited space in the courthouse sometimes, and collaborates with our other departments to make sure we address ordinance violations. He's also been actively involved in some warrant and amnesty programs since municipal court handles traffic cases. Sometimes people, surprisingly, don't pay their traffic cases. That will often result in their license being suspended, which then leads to a whole series of other events when they get pulled over or have an encounter with police later in the process. So what we often will do now is looking at doing an amnesty program, waive the fees, waive some of the additional fines to allow folks to come in and address that underlying traffic case so that they can get their license reinstated. Our probation office is one of our shining stars here that is a model for other misdemeanor probation offices in the state. Chief Allen is with me in the back of the room as well. We handle well over 2,000 misdemeanor probationers a year. They create a pretrial diversion program where they supervise the folks from the solicitor's office pretrial diversion program. They supervise certain domestic offenders, and we have a limited pretrial services program, mostly folks on some type of electronic monitoring, and a handful of folks that are on some type of supervised release. And they provide a variety of services, not least of which is a very novel approach of allowing access to a social worker for folks coming in for their misdemeanor probation check-ins. These are folks that might have an inability to pay, might have job issues, anything of that nature. They can be referred to a social worker as a partnership with the School of Social Work here at UGA that is looking to connect them to services in the community, job assistance, resume building, etc. We are also looking at a grant process that the mayor is aware of and a partnership with Harvard University an application before the Arnold Foundation that would look to expand some of these efforts, especially access to a social worker, but provide that at the pretrial level as well. Our diversion center that was created under the last SPLOST now has 80 beds. It is very active. It's about a 65% overall success rate. We have folks that are referred to there from our drug courts that are having issues being compliant in the community. We put them in that diversion center where they're still released daily to go and work as sort of a stepping stone to not have to revoke them back into jail or ultimately into prison. They provide a variety of services, including community-based support groups like AA, NA, GED, et cetera. Our accountability courts, I can't say enough about those, but I will say very little here, other than the fact that we have pretty much every accountability court program that we have as an opportunity to divert folks with either mental health issues or substance abuse issues, to divert them into a community-based treatment setting to allow them to remain in the community and not be incarcerated. Here is the gist of it. Looking at just our 2018 graduates, of which we had about 54, according to an economic study done by the Carl Vinson Institute for the average amount of statewide benefits of an accountability court graduate, those 54 people gave a net gain to not just the community but the state of Georgia of over $1.1 million. These are individuals that are now employed, so they're paying taxes on their income. They're also living, renting, buying houses, and being active members of the community, and therefore returning that money back into the community. And also obviously not being in our jail. As Commissioner Neesmith mentioned, we have a Justice Mental Health Collaborative program. Again, this is an incredible program of which, compared to just about anything else, this is what makes Athens, Athens. The amount of collaboration that we have with our partners in our other areas here is to be commended. This is a partnership between the police department and Advantage Behavioral Mental Health, which is our community service mental health provider. Under initial planning grant, they created a program where a social worker is paired with a police officer. That's Officer Cochran in the police department. What those two folks do is they are what is akin to an immediate response team when it comes to folks having a mental health issue when being encountered by the police. They can be called, they can come to the scene, and they can assess and diagnose sort of on the spot and refer somebody over to treatment and services, because a lot of the folks that have a mental health issue that come into contact with our police department surprisingly have been or are current patients of Advantage Behavioral Health, being the community service provider in the area. This process also allows a social worker to follow up with folks that come into contact with the police department and have a mental health issue. The big part is about 90% of your police force here in Athens is CIT trained. That's what's called Crisis Intervention Team Training. That's a 40-hour training. It's not required. We do it voluntarily here and have been for many years in Athens. It's a voluntary 40-hour training which allows officers to get training in de-escalation techniques. And that includes suicide issues, mental health issues, et cetera, to allow them to understand what an individual may be going through so that they can do some initial triage in the field to de-escalate that situation and refer them to services. Yes, sir.
So you said that that's not required, meaning not required by the state to do
That is correct.
And then you said that we do it ourselves. So anyways, is it required by ACCPD?
I do not know if it's required for every officer, but I know right now we've got about 90% of the officers that are trained. That is significantly beyond pretty much any other jurisdiction in the state. So much so that this has become institutionalized, that the body that oversees training of police officers, the post officers training council, has basically told Athens, you can do this training on your own now. We do not need to come and babysit y'all anymore because we've done it and done it for so long. We now are moving to the next stage of this, what we're calling an advanced training for officers, and we've got, I think, about 10% or so of the officers that are trained on this. This is going to go beyond that initial CIT training. It's going to do QPR, which is basically the equivalent of CPR for suicide prevention. How to assess and initially diagnose and assist somebody that might be having suicidal thoughts. It is also additional trauma training based on national standards. Implementation of mental health first aid, which is a much more in-depth mental health awareness process for officers, and really allowing officers to understand about the mental health court here and what all the mental health services are in the area. A significant program that's being funded initially under this grant. What I can tell you is that looking at some of the numbers there as part of the initial process, folks went back and looked at our jail records and looked at all the arrests over a certain period of time, and they noted that a significant portion of our population had contact with mental health services. But not surprisingly, at the same time, we had a significant portion of those folks that had mental health issues. They were staying in our jail 2 to 3 times longer than other folks. And that's what you do sometimes see nationally, folks with mental health issues staying in jail longer. But now that we're getting some of this data and making ourselves more aware, and Officer Cochran and Katie McFarland and Advantage are going through every arrest record in this town and going through and flagging them for issues of mental health and issues so that they can try to address that and see if they need to be linked over to mental health services.
I believe, Mr. Mayor, that the police department has asked for an increase in the staffing. Instead of having one mental health professional, adding one more, which, I'm going to fully support. I've seen these numbers. It's pretty amazing. And of course, as in most towns, the biggest mental health hospital is the jail. Our facility is the jail. And these people need treatment. They don't need to be in jail.
Similarly supportive of that second position.
I'm also hoping that the police department will require, I think that's where you were headed, will require this training and really look at that training and see how it can be improved and even some follow-up. I'm aware of a situation or two where the officer really could have handled the situation much better than what the video showed. I want that problem to go away. People need help rather than being taken to jail for misbehaving.
But to your point, Commissioner, if I may, and I believe this was actually one of your constituents, we understand that sometimes police-citizen encounters are not ideally what they should be. But part of this collaborative effort is also an after assessment,
Yes.
after that initial contact. I believe one of Commissioner Neesmith's constituents had one of those encounters. It wasn't as pleasant as that individual would have liked, but part of that review of that file afterwards flagged that individual for a follow-up, and a social worker actually called the individual, reached out to them, and got them connected with services.
That individual is in treatment now.
So those kinds of efforts, which seem fairly simple and straightforward, are sometimes difficult in a bureaucratic system and in a complicated criminal justice system. So these kinds of rethinking about how we encounter and how we approach folks in this collaborative effort is really to be emulated. Even to the point where we're working as part of this program with Envision Athens to extend some of that mental health awareness training to local nonprofits, churches, and businesses in the area that want to be more trauma-informed.
Yeah, I have a question about, you say that folks with mental health issues tend to stay in jail longer. It's my understanding that many mental health medications are prohibited. They're prohibited from accessing those medications while they're in jail. Even things as simple as anxiety meds that, highly functioning people take commonly, like Klonopin and Zoloft and things like that, are prohibited in the jail. So how are these folks supposed to get stable if they're off their meds? And even when they get out of the jail, it takes weeks to stabilize back on those meds.
Right. That's an unfortunate side effect of the criminal justice system, that someone that goes into contact and goes to be incarcerated for even a shorter period of time as a day, getting off some of those psychotropic medications that help somebody be well-functioning in society, they can decompensate in a very short period of time. It's unfortunate that once folks go in, generally it's prohibited for them to bring in outside medications. So it may be a 48-hour or 72-hour period before once somebody has been in jail, before they're even medically reviewed, and at that point they may be able to begin some type of treatment. But a lot of the processes that medications are on what's called a formulary. Essentially, when you've got a list of here are the approved drugs that under the medical agreement with the treatment provider that the jail has, here are the types of things that we can prescribe. And they're more generic versions of things. But we know folks with serious mental illness may need a very specific type of prescription medication, which may not be on a formulary. So we may give them an alternative, which may not be good and could actually cause them not necessarily decompensate, but not have the intended effect. So one of the things that we talked about in criminal justice reform but didn't happen legislatively would be allow a process that folks could bring in an outside medication with an approved prescription to allow folks to continue on this. That hasn't happened. That would be something I'd certainly encourage y'all to advocate at the state level, but it is a serious disconnect. That said, I know our folks at the jail work very carefully with the folks at Advantage Behavioral, if there are folks that have been in contact there, so that they can arrange as best they can to make sure that those medications are available to them when they get out.
So it's a state prohibition unless
It's
there
a legal
is an
prohibition.
outside medical provider that can verify the medical.
It's a lengthy process because ultimately when somebody is incarcerated, the sheriff's office is responsible for them. So just having somebody come in off the street and say, give this person this thing and shaking the little pill bottle isn't sufficient. They've got to verify that. They've got to know that that's not just a valid prescription, but it's actually a valid diagnosis. And that process takes time, even when somebody is incarcerated. So it's a process that's not as smooth as possible.
What do you mean by a valid diagnosis? That they question how is that validated?
When folks go through that review process at the jail, it's through a medical review, and they have a treatment provider that the sheriff's office contracts with. They have their own psychiatrists and doctors that have to review that individual themselves and not just rely on some external diagnosis that may be from the community. Because they have to verify, is that current and pending at this time, and is this medication appropriate? It seems like an extra step, but because the sheriff's office is responsible for the well-being of that individual, they have to be that thorough. This is an area where that's sort of how the law is written in this area. So very quickly, sheriff's office, again, lots of efforts there over at the jail for GED program and Inside Out prison exchange program where they pair students in the School of Social Work to work with folks in our local jail. They have a lot of additional training in things like moral recognition therapy and things of that nature, which are sort of cognitive-based treatments for folks that are in our jail system as well. But here again, other local efforts at the civil end of the spectrum. We do quite a bit of alternative dispute resolution because we know that folks can't always afford an attorney. So we try to address as many cases as we can through mediation and provide our divorcing parents program here at the courthouse. We have new self-help services here that's based out of our law library. To date, we help about 10 or so patrons every Monday from 10 to 2. It's a volunteer lawyer program through a cooperative agreement with our law school that helps folks get access to legal services out of our self-help center. We also have, as a partnership with our local bar, the pop-up clinics, and I believe we're on our sixth pop-up clinics. 10 plus, okay. So we're doing those regularly. We serve about 25 lawyers show up for those to assist, including judges, and they usually serve about 30 to 75 patrons dealing with issues on family law, landlord-tenant, disability law, small claims, and general civil issues. Our clerk's office has also made available public access terminals in her office for folks to e-file documents as well as to look up documents as well in the clerk system. So as we look into our next steps on the criminal justice system, one of the things that we can look at, piggybacking on where some of the state-based reforms left off, is to revise our current bond schedule with increasing the number of offenses that might be eligible for an OR release. That's called an own recognizance. Basically, somebody being released on their own good faith to show back up for court and to deal with their issue. We can increase the use of citations in lieu of arrests, again, for those 5 or 6 misdemeanor offenses that now can be issued by citation. We can expand our pretrial supervision and process. Yes.
Thank you. I was gonna. I know earlier you mentioned we're waiting on some things to kind of trickle down from the state level. Are you aware of what our timetable is of waiting that out with regards to use of citations in lieu of arrest?
Yes, I'm going to kick that to Judge Hope in just a
Okay.
moment, who's going to close us out with some of the more specific efforts that we're making. So I'm
Great.
kind of giving you the quick list and then handing it off. We should expand our pretrial services component. Our county misdemeanor probation office is well suited to pick up and handle some of that. They've already been doing that on a limited number of cases. They can do more. We should implement our criminal justice dashboard. This is one of the things that we developed with our last SPLOST money. This is an opportunity for judges to have at their fingertips a broad-based approach on what's going on with an individual in our local criminal justice system, to see all the cases that they're involved in, their jail history, their criminal history, et cetera, to make a quick, more informed response on how to address an individual. We can do a procedural fairness assessment of our process to get some feedback from our constituents in the system. We need to do a system-wide review of our arrest and jail data, which we've been doing sort of sporadically. We did under this criminal justice mental health collaborative program. We need to do more there. Increase access to social services, both at the pretrial level as well as at the reentry level, and continue our criminal justice partnership, which Judge Hope will cover in a moment. On the civil side, we need to increase the access of our self-help center, make that more available to folks, and increase the number of pop-up clinics, expand the use of mediation to include online dispute resolution. Not surprisingly, a lot of folks do things online these days, and based on a national survey, a good number of folks want to deal with court issues online, including landlord-tenant, traffic cases, and what are called account cases. That's an individual that may have a delinquent credit card or things of that nature that they can deal with that online through the court system. And obviously making better use of technology, kiosks, online access, et cetera. So I'm going to hand it off to Judge Hope, who has been tasked by our judges to be our lead judge on our criminal justice partnership effort, and he's going to tell you a little bit about what we've been doing and what some of our next steps are.
And I don't know if I stole Judge Haggard's parking spot or why he asked me to be the one to lead this, but I was happy to try to help out because some of the initial projects that we're working on are things that you know because I've emailed you incessantly about some of the progress. Some of the initial projects are things I was already working on. And so you've seen kind of historically what we were doing locally, and some of it's been in specific courts, state court with DUI drug court, some of the accountability courts, and on these small scales, you see these collaborations that have been very successful. And I'm lucky enough to have been a public defender that started in a system that was supposed to be adversarial and start in a court that's starting the DUI drug court, and people are trying to collaborate and work on solutions and not just be adversaries all the time. And so Judge Haggard has, I think, recognized that these small collaborations are working. Why aren't we collaborating on a larger scale? So that's the point of the criminal justice partners. We've only met twice so far. We have a lot of elected and appointed officials who have meetings, much as you guys do this month. Your schedule's very busy. And so we're not trying to meet to death, but we want to meet frequently enough that it's productive and it's helpful. And the idea is, can we get more eyeballs on these issues? Can we think up of solutions as we have prosecutors there? Mr. Malden and Mr. Chisholm have been present. All the judges have been present. Sheriff's Office, the public defenders, Chief Assistant, and John Donnelly. We have all different facets of the criminal justice system meeting and talking about some of these issues. And some of the reforms we've seen on the state level and on the local level, they've been on what are we doing on the back end that could be better at sentencing, at parole. What we're focusing on right now and what the current trend is on the state level is on the front end, can we start making better decisions where maybe people don't come into the system in the first place, or if they do, we're making decisions that will keep them more stable and more productive as they go through the system so they don't become recidivists. And so some of the thunder was stolen with misdemeanor bail reform was one of the big issues, SB 407 that passed last year that went into effect July 1st of 2018. Magistrate Court has already started implementing some of the reforms required by that. Now, the reforms that are in SB 407 did not go as far as the state reform committees wanted it to go, but it was a good first step, certainly. And it made it more clear that judges in first appearances need to be considering people's financial circumstances. And that especially when they're dealing with an individual on a low-level, nonviolent misdemeanor, they need to be using the least restrictive means to make sure that person will show up in court and won't be a danger to persons or property. And they don't need to have excessive bail. They just need to have the type of bail that will make sure they will come to court and they won't be a danger to persons or property. So one implementation of SB 407 locally has been a standing order that Judge Barron has issued that for first-time misdemeanor arrestees, individuals who have never been arrested before in the state of Georgia, first-time arrest that's not family violence, not stalking, that those individuals are eligible now for an OR bond before they even see a judge. So they are still being arrested, but the jail runs a criminal history. If they meet the criteria of this standing order, they can get an OR bond immediately. They can sign their own bond and appear in court. The other reform is that they are now getting financial information Someone at the jail is assisting as they're preparing for bond hearings every morning. Everyone is required now to fill out a financial affidavit so that the judge has documented information, at least self-reported from the individual, from the defendant themselves, to review as they're making their bail decisions. So they've already implemented those two reforms to be in line with what SB 407 requires. The uniform misdemeanor citation, and I may need to correct an impression, Commissioner Edwards, that you may have about what's going on in that area. That is another form of bail reform. Instead of arresting someone for possession of marijuana or for shoplifting, they're now going to be possibly eligible to just be cited there at the scene and appear. So you don't even have to worry about whether or not the standing rule will apply to that person. You don't have to worry about whether or not they'll be able to make a preset bond or whether or not they would be OR'd the next morning when they see a magistrate. They could be released on citation on the scene. Now, your question about restriction, it was timed at the same time as the uniform misdemeanor citation. So were you thinking that that's changing the penalties because they're now only being cited? I just wanted to...
My question earlier this evening,
Yes.
I was envisioning someone who's possibly in jail right now, having been convicted of an offense that has subsequently had its punishment reduced by state law.
And so what's important to remember about the uniform misdemeanor citation is it's not changing the punishment once the case comes to court. It's just changing what happens on the front end to get that person in court in the first place. So for these offenses, possession of marijuana, theft by shoplifting, criminal trespass, when the person comes to court, they are still facing a case that is punishable by up to 12 months in jail, a $1,000 fine, or both. So it is a bail reform measure. It is not anything that is changing the possible penalty once the person comes to court, and they are still fingerprintable offenses. So it is still something that at some point the system has to process that case, has to transmit the fingerprints and document that that event has occurred. It's just now the person might not be arrested at the beginning of the process. So is that an important clarification?
Oh, yeah, that's an important clarification
Okay.
because I know, in other jurisdictions like Atlanta, Savannah, and Clarkston, where they have a parallel ordinance where they charge misdemeanor marijuana possession, that they can actually mete out different penalties for those offenses.
Right. So this process that was authorized by SB 407 is not that process.
Completely separate.
Two totally different concepts.
We can cite people with a ticket for misdemeanor possession or shoplifting, but they will still come to court and face those same state penalties.
Exactly. And they may be eligible for pretrial diversion or programs where they will get the charges dismissed and restricted. So I have never in 2 years locked up a misdemeanor marijuana or a shoplifting person for 12 months in jail. That is just the maximum possible penalty. And many individuals who are first-time offenders, they are going to be able to utilize a variety of pleas that will restrict the disposition of the case if they complete certain conditions. But I'm glad I clarified that.
Yeah, thank you. That's great.
Now, the problem with that process, as many of you know, is A, we didn't have a uniform misdemeanor citation. So the bill went into effect July 1st of 2018. We have uniform traffic citations. They've existed forever on speeding and stop sign and that sort of thing. But the bill required the Judicial Council to create a new citation for these offenses that would have been arrested in the past. And so we were waiting until probably just before Christmas. Is that about right? And they finally published the document, and immediately there was reaction from local law enforcement agencies about this being dropped on them, even though we knew since July 1st this was going to happen. And locally, we were meeting on a regular basis. I was meeting with ACCPD and UGAPD to be ready once the document was in place. And so they've retracted that uniform misdemeanor citation. They've delayed its implementation until July 1st of 2019 now. The other problem was the way the statute was worded. It said when at the time of arrest, prior to release on citation, the individual had to be fingerprinted, and that was going to be a huge problem for us locally. There was also a requirement that the criminal history be run to make sure the person didn't have outstanding warrants, wasn't wanted for probation violation or something more serious. That was easy. All of our local law enforcement agencies could do that from a laptop in their car, but they did not have the ability to fingerprint at their vehicle.
Judge Hope,
yes,
could you help me understand that? Because I know that we can unlock iPhones with a fingerprint, and if that person's fingerprint's not available, the FBI has trouble unlocking it. I mean, it seems like we have technology out there to capture fingerprints.
Yeah, and there are jurisdictions that
help
use
me
things.
understand the technological holdup there,
It has to
please.
capture a fingerprint that could be transmitted to GCIC, is my understanding. So you need a device that isn't just capable of capturing, of course, my phone can capture my fingerprint, but it can't transmit it to GCIC to be on a criminal history thereafter. So it has to be a device, is my understanding, that is compatible with their system. Now, there's a potential fix. SB 222 that has made crossover day created a new criminal justice reform council. Am I using the right terminology? Since it had sunset, but people who were concerned about this very issue, jurisdictions that were struggling with this very same problem, got some representatives or senators, since SB, to add language that they could identify through other means. So it removed the requirement of fingerprinting right then at the time of arrest. So it's made crossover day. It's been through House readers twice. I'm very hopeful that it will pass. And this would allow an officer to identify somebody through some other means. If they have a state ID or a driver's license, if it's someone just known to that law enforcement officer, even if they don't have an official ID, there are a variety of ways that people would be able to identify and still release on citation, and it would get back to the spirit of what was originally intended. A citation doesn't seem like something you should be taken to jail on. The whole point is you could be released right there on the scene. So hopefully we have a statutory fix that, since we have to wait till July 1st of 2018 anyway, since the document itself isn't created, maybe everything will line up and that might be your timetable. Now, the only other complication, if some of you read my email, was the statute also created a new responsibility for the GBI to create the uniform misdemeanor citation. And so we don't know if the GBI is just going to piggyback on the work that was already done by the Judicial Council and just use that document. That is our hope. I don't know what the thinking was there or what the concern was there, that they wanted to take away the responsibility from the Judicial Council and put it on the GBI. So that would be the only other hiccup. Are we going to have a document on July 1st of 2019 that we could use? But hopefully, if everything lines up, our local jurisdictions, Athens-Clarke County Police Department, UGA Police Department, they want to do this for possession of marijuana and for theft by shoplifting. They want to start there. Those are cases that already come to municipal court. The subject matter of those offenses is very easy for officers to deal with. Criminal trespass is the other possibility down the road, but it's a statute that can be anything from a nuisance at a retail location to on the verge domestic violence situation. And so that's just a lot of subject matter for officers to deal with and to decide, do I need to arrest, do I need to cite? So let's start with these easier, low-level, less public safety involved cases, and let's see how this works.
And Judge Hope, what's the threshold for shoplifting now?
I believe it's 500, if I remember correctly, now with
500.
the change in the law. It used to be 300, it's now 500 to be misdemeanor theft by shoplifting, and you have to have, you can't have 3 convictions already to be eligible for misdemeanor treatment. If you have 3 prior convictions, you wouldn't be eligible for the citation because it would be a felony offense based on your prior convictions.
Okay.
The flip side of all this, if you are releasing people earlier on OR bonds, if you are releasing them on citations, the concern is your failure to appear rate going to go through the roof? Are people going to ignore the case and not come to court? It is important to note an OR bond is still a bond that the courts can deal with. If somebody doesn't show up to court on an OR bond, a bench warrant could be issued. If the OR bond has special conditions, like don't go to this location, don't contact this person, and the state is able to determine that that may have happened, they can file a motion to revoke that OR bond and hold the person in jail if it's found by the court that the person has indeed violated the special conditions of bond. So that's where the Arnold Foundation grant that was mentioned earlier is hopefully going to be very helpful to us. The case management system in municipal court has a capability to do notification, so I'm already in process of activating that feature, and the county has been very supportive of giving us or offering us some money because it is going to cost money to implement this procedure. But the great thing about this grant is that we've got Harvard, we've got UGA School of Law, UGA School of Social Work that would be doing some analysis of what is working, what is not working. There are a variety of tools they're going to be using. One is what they call plain language citation. If you've ever read a citation, it's not always easy to understand, even for the lawyers that have to deal with them. So if you have a citation that's in much more plain language, is that going to make it easier for people to understand when they need to come to court? The text and or phone call notifications And then also this possibility of a case manager or social worker that would check in with the person in between their release on citation and their court date, make sure that they understand the importance of being in court, and also maybe hook them up with services that will keep them more stable and more likely to appear in court. So that's what you need to do. You need to partner these reforms with also some accountability to make sure that people actually appear and respond to the charges.
Well, and it costs a lot of money when people don't show up to court, right?
It can.
You gotta
That's
serve
your hope is
bench
that,
warrants and
it's
get
a
the
public
sheriff
service.
involved.
You know,
Yeah.
if people are going to be there, it's a more efficient process.
Yeah.
That's better for everyone.
Right.
But it saves money on the back end. If you don't have to issue failure to appear suspensions that then lead to a driver driving while license suspended, or bench warrants that you have to process and arrest the person on. So that's why, even if we weren't doing this reform, the notifications, I think, are something we should be doing anyway.
Yeah.
And so the plan is, right now, once again, let's start that in municipal court. I've provided the documents that we've added. We've revised our bail forms so that they have to provide more contact information when they post bond, an additional phone number, not just one phone number, an email address, so we have more ways to reach out to someone. Those forms I've provided to the state court judges, the superior court judges, Beverly Logan, who's state and superior court clerk, so that they might be able to also, we unfortunately have different case management systems, that they might be able to also use their systems to do notifications even on felony and higher level misdemeanor cases. And so those are our main projects right now, as if those aren't enough. I know Commissioner Parker was very interested. We were in a breakout group about local reentry issues, and so I think that's one thing that we could really start to work on, are some more local reentry. And it's a really difficult concept. When you have a parole, you know tentatively when someone's getting out, you can game plan a little bit better. When you talk about reentry at the local jail level, you don't know if someone is going to get OR'd very quickly, if they're going to be in jail 10 days, 30 days. So what processes can you put in place at the jail itself? What services can you link with, maybe through the mental health collaborative, to make sure that when someone does get out, there's a game plan in place that does keep them stable in a better place. They're not going to reoffend while they're out on bond. They're going to be more likely to come to court. I think that's one of our big projects that, because we have such a big group and all these eyes looking on an issue together, is something we could really be working on. So I think that's about it that I wanted to say, if anyone has any questions.
When it comes to marijuana possession, from what I understand, folks that are arrested just on possession make up a very, very small amount of, I mean, there's usually other charges involved. And I'm looking at these statistics on the types of charges, and the top charges that land people in jail are misdemeanor probation violations, felony probation, misdemeanor driving violations, felony nonviolent non-drug charges, and misdemeanor trespassing. I'm wondering if we can look at some of those charges to see, I mean, and sometimes from the conversations I've had with public defenders and personal experience from folks I know, these folks are getting, you know, they're ending up arrested for incidents, usually mental health related incidents that are minimally violent. You know, they might be having an outburst, throw something. I mean, if that lands you in jail, I've thrown some crockery in my day, and I should probably be there too. So I'm wondering if there are any clear standards for what constitutes charging someone with something like criminal trespassing.
So you're talking about criminal trespass to property where property was damaged?
Well, and often these, you know, folks are being charged with criminal trespassing at their own home.
Okay. Unless you've
In
been
lieu
barred.
of being charged with a domestic violence, there's, you know, it doesn't constitute a level of domestic violence, but there might be some property damage. And from the cases that I've heard, it's extremely minor, you know.
For criminal trespass purposes, if you were being arrested, you were typically barred from that location and returned, or you damaged someone else's property. So you can't be arrested just for being in your own home unless in some way, shape, or form you were barred from that home and were no longer allowed to return. So that may be a better prosecutor question than a judge question. You know, I was a public defender, I was also a prosecutor.
These other charges that get laid on that land someone in jail for offense, and typically there's mental health issues. And the last place these people need to be when they're in an agitated state is in jail, where they don't have access to their meds.
And that's where the collaborative is huge, because the whole point of the collaborative is a co-responder model where both parties respond. If they can do some safety planning right then and there and they can diffuse the situation, then maybe that's it. If the person is in active crisis, the hope is that the link up with Advantage and their new facilities out there, that you can take the individual straight there into crisis stabilization and they could get actual treatment, not just be housed in a jail. That treatment is ancillary to their primary purpose. So I don't know if I'm allowed to advocate for something, but I would echo what Commissioner Neesmith said. Expanding that program would be tremendous. I mean, we have plenty of business coming into our courts. People could be diverted before they come to our courts and receive more appropriate treatment early on. That's beneficial to the community in general. I would absolutely agree with you. When you mentioned being arrested on, traffic offenses or some other minor offenses, any offenses that come to municipal court, if by 48 hours that person has not been able to post whatever bond they have, whether it was the preset amount or when they saw a magistrate, the magistrate wasn't willing to OR them, they are OR'd at the 48-hour mark based on an order from me at that point. So no one certainly at pretrial detention level is spending more than 48 hours in jail for an initial arrest. On the probation violation side of things, it was a real brief part of the state court slide, but it's also the process in municipal court for individuals who are reporting to their probation officer. If they're not paying and they're not doing community service, we do not arrest for probation violation based on those issues. So if they're reporting, if they're actually communicating with their officer, but they're having financial hardships, they're having other hardships that make it difficult for them to comply with their sentence, we have a walk-in process where they just come in and we discuss the issues. We try to figure out where the obstacles are and see if we can come up with solutions instead of arresting. And so every single person I sentence to probation, one of the things I say to them is, the fine that you are receiving here today is the least important part of the sentence as far as I'm concerned. I care about you reporting, staying out of trouble, and communicating with your officer. As long as you'll do that, we can make it through this probation. So I think we've instituted processes, at least in state court and municipal court, that try to deal with the issue you're discussing. But we do have people who are on probation that commit new criminal offenses, that just throw up their hands and stop seeing their probation officer. It's 4 months down the road and I finally get a warrant, and typically if I see a warrant that I tried to call them, I sent them a letter, they haven't come in to see me, I am typically going to sign a warrant that has that type of allegation on it. So does that somewhat answer?
Kind of. I'm
On the prosecution
Yeah.
side of things and the discretion side of things, what you might be describing would also be potential domestic violence questions. There are some limitations there, and those are probably better questions for law enforcement or for prosecution to answer that kind of discretionary in a domestic violence situation.
Yeah, I mean, I'm concerned with instances that I feel shouldn't even land them arrested in the first place.
I understand that. I understand.
Judge, what sort of conditions could be placed on bond to divert people into this service regime that we're building in this community?
Judges can set whatever conditions we want, just about, and it's the follow-through. How do we make sure it's actually happening? You have a lot of HIPAA and privacy issues, so yes, go to Advantage within 10 days and make sure you continue taking your medications. How do I follow up and know that that's actually happening? That's where we have the holes, and that's where can we get a more consistent kind of local reentry process where we either have releases or we have a case manager that can provide that information to the court, and we can really check up on that. Because that, from arraignment to appearance in court, in my court, is usually 30 to 45 days. State court, do you know what you guys are at right now? 60 to 90. So that's a big time period where a lot of bad things can happen.
Right.
And we can set the conditions, but our ability to effectively monitor them is limited.
So is there any office or entity that could act as a probation office almost, where people would check in and show that they are complying, or check in like the diversion center, or checking in with a bond officer? Or...
Yeah, probation performs that duty a little bit right now, as was mentioned earlier, with at least electronic monitoring, and there have been some other cases where a judge has decided this isn't exactly a ankle monitor, I need to know you're in your house, this isn't a monitor where I don't want you consuming alcohol because you're a repeat DUI offender, but there are some things in your life that I think need attention, and so they'll assign them to the intensive supervision unit. Is that right, Officer Allen? Chief Allen? But they don't have the resources to do that on 50 cases or 100 cases for just the non-electronic monitoring. Am I accurate?
It would be a stretch, but we can do it.
So we do utilize that. But you really have to figure out, is this the one case I need to do it on? Because I might not be able to do it for another week or two. It's something that would need some resources to beef that up.
Well, and this seems to be pertinent in the mental health area where someone has an episode, they're arrested, they get bond, 60 or 90 days until their court date, but they need help.
Yes.
So what's being done now in those cases?
I think expanding the collaborative could be helpful there because I think they're willing to also supplement as pretrial release, but right now with just one officer and one clinical person, they just don't have the manpower to do that.
So the mental health court is not,
It is if that person's being sentenced.
Right.
And there are some people who would come before me, let's say they're on probation with me, and they've had a variety of violations, and it's clear to me it's because they're not stable, and I can't get them to get to advantage on their own on a regular basis. I may make a condition of release. Okay, you need to meet with the coordinator of the mental health court. I might even do a transport order that upon release, they're taken straight to the courthouse to at least start the screening process. Now, if someone's still in crisis and
but
they're
that
not
would
very...
that would be a probation revocation. That would be
Or
somebody
sometimes-
already on probation.
Or sometimes at bond. That can happen at
bond?
bond as
Okay.
well, yes. So since I don't see my first appearances, I wouldn't do that at bond. But I was involved in special bond hearings where the mental health court coordinator did come and give a report. They were able to get a release and tell the judge, well, this has been the history. They are an advantage client, but they haven't been there for 6 months. And that gives some information to the judge and helps them plan for what's the best set of special conditions to set here. But once again, it's how do we link all that information once they're out? Can we get appropriate releases? The Public Defender's Office, well, Ms. Benjamin has left, she used to do a lot of those hearings. They will represent people at these types of bond hearings, but once the person gets out, if that's the only time they've seen them, they won't always consider that an officially open file because they don't have a lot of information on that person. They'll expect them to come into their office and open up a file, and so you're left with not having a good individual to report back to the court unless you can get those releases, can get the mental health court coordinator to agree to do that for you. It's not one of their primary duties, but it's something they've offered to do on special cases.
What can the commission do to fill this need, this gap right here?
Resources. Where it would go exactly, you'd have to talk to some of those departments, and that might be one of the projects we need to look into. Where we want to beef up these issues, who wants to take on these responsibilities, and then make requests to the mayor and commission. I don't want to tell you, give money to mental health court because they'll do this. It might be that a social worker within the probation office and their pretrial release program could also be a possibility for such a program. And I know this is something that Mayor Gertz has talked about, is trying to figure out, can we beef up our pretrial release processes, and especially these high maintenance cases or high risk cases where if you can just get them into services, you're going to have a much better outcome. How can we make that happen earlier on in the process?
I would love to be asked, shown a plan for beefing up these kinds of programs, like the companion program, so that we can get a little more serious about it. We're just touching the tip of the iceberg, not even that.
And like I said, the focus in reform up to now has been, once they get to court,
Yeah.
once you're sentencing them,
Yeah.
how can we get at the root issue? But for some of these cases, doing it earlier on is going to
Yes.
lead to better outcomes.
When actually they don't need a sentence, they need treatment. Are there any state reforms that need to be made to help, for example, the companion program?
Not that I'm aware of. I mean, the
Okay.
officers have discretion when they're there on the scene, and if they have a clinician that can assist them in figuring out what is really going on, they have some discretion to make a decision there on the scene.
Okay, so we don't need any state laws, any more justice reforms that you can think of now that would help make these things work better? If you do, let us know. We'll ask our delegation to do something. They might even do it. You never know.
Sure.
Oh, I didn't say that.
One of the things that the legislature is looking at, governor's office included, is creating a mental health task force.
Yes.
Because of this
The commission,
interplay
actually.
of mental
commission.
health and the jail and the prison system and all that, and looking at how can we share resources, how can we coordinate that better. Ultimately, is there an opportunity for some legislative fixes? Yes. I mean, the biggest issue we have, and not unfortunately, is a privacy concern.
Yeah.
That we might have somebody right before us in front of a magistrate that obviously may have some needs, but we can't contact Advantage and say, do you know this person?
Right.
They'll kind of look at us sometimes and nudge and wink or something perhaps, but we can't get an official release until we get that individual. They may not be in a state of mind that they want to share that information and sign those releases. So there might be some fixes to be able to share stuff collaboratively that would allow us to at least acknowledge that they are in contact with Advantage. That issue of the jail and medicine, waiving the liability for sheriff's office to bring in outside medication to be able to get access to that quicker so that
Yeah.
folks have access to the meds. So there are some.
So
some
maybe
slight
that,
fixes to
that
look
new
at.
commission, if it gets formed, mental health commission will.
That would be an opportunity to
will-
bring those kind of
yeah.
issues to them.
I know this, I know the community service boards are very excited about that.
Just building off of what Commissioner Link brought up with some of those extra charges being added on to some of the nonviolent, like specifically marijuana possession. I saw some numbers now. A lot of those things were like minor traffic, brake light not working. There was a lot of that kind of stuff added on to them. I saw things that I've been pulled over for but never arrested for or charged with actually. So my question with it is how much does that, having those multiple small infractions being added on, how much does that complicate being able to get them again out of the court system as quickly as possible?
So for the scenario you're talking about with a brake light violation and a marijuana charge, if the Uniform Misdemeanor Citation Law can get processed correctly, that person would then be able to be cited because you wouldn't be arrested on a brake light violation. So the confluence of two citable offenses would say, I can now cite you. Stop for speeding, I can now cite you. Now, if during the traffic investigation the officer has concerns, has probable cause to believe that that person's under the influence of marijuana to the extent they're less safe to drive, then that person would typically be arrested for DUI and possession of marijuana. So most traffic situations would become citable under the circumstances that you're discussing.
Right, but in our current situation where they are brought before a judge, though, is there a complication with that fact that they now have, say, 3 charges being?
Yes, okay, so I understand that then. With the preset bond schedule, there is. So there are preset bonds for minor offenses like brake light. It might only be $500, but if the arrestable offense had been a $1,500 and they have 3 or 4 traffic offenses, it could become a $5,000 bond. And so that's why the analysis, and Magistrate Court is doing this currently, the analysis of what the bond schedule is it still appropriate? Because I think it was set some time ago. That's where that can be really effective, and that's something Magistrate Court's doing right now.
Okay, and on that, and this is going to be answer the best you can, but like, how much does it increase the likelihood that they are charged with, say, with some of those minor traffic things, such as a brake light, because they also have that possession of marijuana charge there? Like, how many people do you actually have come before you because of a brake light infraction compared to how many people do you have come before you with a brake light infraction tagged on to one of these other nonviolent?
Well, usually the chronology of events is that traffic offense is what drew the officer's attention in the first place. So they're usually already going to have that traffic offense because that's why the officer pulled them over. Now, it might be a situation where they would have warned the individual, but I do get just straight brake light tickets in my courtroom sometimes. And it might say on the ticket, I pulled this person over a week ago, I warned them about their brake lights, and I've now seen them again, I'm giving them the citation. So the chronology of events is that the traffic issue is what drew the attention first, and then during the stop, at least in the cases I'll see come in my courtroom, allegedly odor of marijuana or maybe seeing it, and then that's what leads to the arrest.
And that makes it less likely that they would waive those smaller traffic violations?
It's hard for me to say because I wouldn't know the times where they just gave them a warning if they only came in on the marijuana, unless they went to trial and that came out as a fact during the trial itself. So that would be an individual officer discretion kind of thing. There are officers who definitely would say, well, I've now found something that in my mind is more serious. This is a fingerprintable misdemeanor, not just a traffic violation, who would just say, I'm not charging you with the brake light anymore. I'm just going to arrest you on the misdemeanor marijuana. So I've seen it both ways, but statistically, anything I told you would just be anecdotal.
Okay.
So from what I understand, these misdemeanor traffic violations or driving violations, a large number of them are driving on a suspended license or an expired license, which, is an offense that's directly linked to poverty. I mean, I think the last time I renewed my license, it cost like $80. For a lot of people, it's hard to scrape up $80, much less get yourself out to the state trooper's office to get that license renewed. So, how much discretion is there in taking those in actually deciding whether or not to charge those folks and them ending up in jail. From what I understand, there's a lot of people sitting in jail for driving with a suspended license, and then they're just racking up more and more charges and probation fees, and it just spirals out of control, and they can never really get their license back and never get a job. So I'm wondering if we can delve into that whole issue of just getting people's driver's licenses back, or seeing that they don't end up in jail for these things.
I wish you would come to a municipal court arraignment morning or a state court arraignment calendar and see the number of cases that the only reason they're reset is because they're allowing the person to continue working on reinstatement. So on the front end, that's not an answer to your question. But once the case comes to court, the sole goal of almost everyone in the system, and I think Mr. Chisholm would echo this, is can we get this person to get their license back? Because we know it's going to improve their life. We know if they do have to get behind the wheel of a car to go get medicine at 2 a.m. for their baby, that they're not going to be arrested when they decide to make that decision. So we reset cases constantly to give people an opportunity to get reinstated if it's a suspension, to finally get a license. I have people that come into my courtroom that are 30 years of age and they've never had a license, and just something happened this one day, they got behind the wheel of a car, and it's when they got pulled over and they were arrested. So as far as once it comes to the courtroom, as long as it's someone who's not a public safety concern. So some suspended license cases are really serious public safety concerns. They're repeat DUI drivers, fleeing and attempting to elude, aggressive driving, racing. They're people you might not want driving on the road anymore. But it is a significant portion of individuals. They didn't pay a ticket in Barrow County or in Winder or in Arcade. And they are a failure to peer suspension because they didn't show up, they didn't pay, so they are administratively suspended. They keep on driving, they get arrested. So we'll reset those cases and we'll say, go pay your ticket at Arcade. We'll give them direction in the courtroom. These are what your active suspensions are. This is how much it's going to cost you at driver services to get reinstated. We let them know they now have a financial hardship waiver at driver services. So let's say you have $500 worth of reinstatement fees. They won't advertise this, but when you get there, ask them for the financial hardship waiver, because if you qualify, it's only going to be $250. It's not going to be $500. So pretty much every morning, Monday through Thursday, you would hear those conversations happen. Prosecutors with pro se defendants, defense attorneys with prosecutors, people in front of me. That's what we are doing repeatedly is trying to educate them about what the kind of end goal is and how to get there. The discretion at the front end, once again, is probably a better question for law enforcement as to when they take action, when they don't take action. I think I did send to the commissioners the statute that deals with Title 40 offenses and that indicates for speeding, stop sign, the reason you don't get arrested when you get pulled over for those is you present your license in lieu of arrest. Well, if you've never had a license, you don't have an ability to get a license for whatever reason, if your license is suspended, you don't have a document to present to that officer, so it would seem that that statute would mandate arrest. But that's a conversation that the local law enforcement agencies would need to have, or perhaps with the assistance of attorneys who could give them advice. But especially for people where it's clear, failure to appear tickets, we know that person didn't show up because they couldn't pay the ticket. I have a policy of, as long as it's within 6 months, they could be reset 10 times. I don't care. As long as the case isn't older than 6 months, reset it. Let's see if the person can get their license back. If they're a first-time offender, the case is going to be dismissed if they get their license back. If they're a repeat offender, it's at the very least going to give them a better outcome. The jail side of things, it would apply that 48-hour comment I made earlier. If someone is in jail and they're driving without a license or driving with a license suspended, it's a case that's jurisdiction would be in my court. If at the 48-hour mark they haven't made bond, they're going to be OR'd at that mark. Can we shorten that? I hope so. The studies show even going from 48 hours to 24 hours, maybe when you see that judge the next morning, shortening it that much actually increases reduces your recidivism rates and increases your public safety because you've got someone who's that much more stable. If they're on a point system at the poultry, being out of work 2 days might make you lose that job. Only being out of job that one night might not make you lose that job. And if you still have that job, you're going to be a much more stable, productive individual.
It's been great.
Judge, I have, and this can go to TJ, anybody in the room who can answer it, because this is maybe a tough one. Could y'all give me, even if a rough estimate of what like the average legal financial obligation that is on a person, say, leaving state prison?
Ooh, I would not be able to answer that question. I know Chief Allen has been involved in a lot of reentry meetings. Is that a stat you've ever heard anything about?
I'm not sure I understand the question.
How much a person is legally obligated to in fines or in service fees whenever they leave prison?
Okay.
Do they
So if
have hanging around their neck as they leave?
So if they,
Normally, I don't think they have a lot. TJ, you can correct me if I'm wrong, because hopefully they paid their fine and fees, and that was one of the things of criminal justice reform at the state level. That's what they were finding, keeping these people on felony probation longer than 2 years just because he owed fines was counterproductive. It shows that most people pay their obligations within 2 years of getting out of prison, say coming on probation. They pay most of their fines and fees. After 2 years, if you haven't collected it, it's not worth the effort. So, first of all, criminal justice reform addressed that. The more important thing that I would like to put in perspective on that is the old school way that TJ talked about initially was.
Hale, would
Yes,
you
sir.
mind coming up? This is televised and they can't hear you back there.
Okay. Sorry, not used to being on TV. But the important thing about the reentry and kind of the financial obligations I'd like to mention is the old school way was you get out of prison, you got about $50 for a food voucher, you got a bus ticket, and a pat on the back, and they sent you. With the current reentry philosophy, with the diversion center, with getting people through the prison system into a reentry program that's coming to our community, now we can get them into like a diversion center, we can get them a GED, we can get them job training, we can get them employed, so by the time they come out of the prison system totally, they could have $10,000 or $15,000 in the bank and a steady job. So I hope that answered your question.
and I think your question is maybe like what we call a split sentence on a felony. So let's say somebody had a serious offense and they were going to get, what we might say a 10-5, a 10-year sentence the first 5 years in confinement. You're wondering, when they're coming out of confinement, what is their financial obligation to the courts when they get out? Okay. I would say locally, and I haven't, I did do felony work for a while. I haven't done work in front of Superior Court judges in a significant period of time now, but our Superior Court judges did not find very often on straight probation cases, and they did not find very often at all on what we would call split sentence, because they knew that person coming out was going to be a convicted felon oftentimes, and was going to have a hard time paying anything when they got out. Now, they would have a probation supervision fee, but it would be one to a state probation officer who oftentimes is just going to, for lack of a better term, let that ride if the person is reporting, is staying out of trouble, is doing whatever other conditions they're required to do, seeking work. They're not going to take them back in front of a judge, especially if they've just come out of prison, over non-payment of their probation supervision fee.
And I hear that we keep on talking about that, like that we're not going to drag them out through it, but the initial expectation is that they do pay it, and therefore there is that expectation put before them, and the ask is there.
Not in my court.
Not in
So
your court, but I guess like in all these other
I
levels,
think-
we talk about even with these reforms, like after 2 years, but we're still saying that we are expecting them to pay it, and we're definitely saying the expectation is levied upon a person who definitely has a lot of financial hardships coming out of these situations.
Well, the statutes now have some of those concepts where people are presumed to be indigent and you shouldn't fine them or you should convert it to community service. So there are some obligations on the judge at sentencing if someone, if they know for certain they're on a disability income, if they know for certain that they've been in confinement, is it more than 30 days in the last 12 months?
Yes.
Is that how it's worded, that they're presumed to be indigent and you should take that into account, not fine them and consider doing community service in lieu of the fine? So some of the reforms at the state level are addressing that very concept. Now, there are charges that have mandatory minimum fines, like DUI, for example. There's a certain mandatory minimum fine that even if the solicitor's office agrees this person is indigent, they have to impose that fine, and that's why I give that speech that I mentioned. If you aren't explicit on the front end, and the person is worried, well, if I show up to a probation officer with no money in hand, he's just going to hook me up, that's what you want to dissuade right at the front end. I understand you might not be able to pay this fine. I have to impose it. Report, do everything else I'm asking you to do your community service, we'll work through the financial issue.
I appreciate doing it on like that's true, but I guess I worry about the
Right.
the situations that judges where that's not being done explicitly.
And I have some pro se people who are representing themselves and communicated with the solicitor and reached an agreement. And let's say they agree to pay a $700 fine on a shoplifting. And they come in front of me and they tell me I'm on a disability income, I only get $735 a month. Judges aren't supposed to interfere in plea negotiations, but I'm going to turn to the solicitor right then and there and say, we are setting this person up for failure. Can we consider right now doing a conversion into community service hours? So that $735 fine would become some amount of community service hours. If that was a person who didn't feel they were capable of working at Habitat for Humanity or one of our local parks, they can come and just observe court, and I'll let that be their community service. So we are every day trying to manage the issues that you're concerned about on the misdemeanor level. And then on just my experience with our Superior Court judges, they understand, especially if they're convicting someone of a felony, that the chances of them being employed are diminished greatly, and so they don't want to set that person up for failure. The one exception would be issues of restitution. The statutes are very strong that where there are victims that have damages, that the system does expect legitimate efforts to make the victim whole. So that is where you'll see one exception. But still, most judges in practice are going to be as understanding as they can, because if they lock someone up, they're not likely to pay.
Would you say those same links that you and other judges here locally are going through are commonplace across the state?
I would not.
Okay.
So everybody, we've got a handful of tangible things that I've written down, taken notes on. So there's, real interest in beefing up that pretrial environment with support like that of a social worker. Obviously, some of that's going on through Chief Allen's probation office right now, but we can certainly engage in some continuation and expansion of that. The additional mental health support we've talked about, and I'm going to be asking you for approval of that in the budget. Utilization of and expansion of the contact system that Judge Hope mentioned, so that we've already got that underlying technology in place at every level to be able to say, we're going to text you, we're going to email you, we're going to ask you if we can text your mama, so that she's going to be riding herd on you as well, and that we get that reentry support.
Yeah.
So some others that you'd add to that?
Yeah, I guess one I would like to put in that came up was looking into requiring the CIT training for all ACCPD officers.
I forgot to mention.
Okay,
I confirmed
fantastic.
an officer in here. If there is a 90% number that's accurate, it's probably new officers that have not yet gone through the full new officer basic training, or officers who are very senior, are never on the road anymore. Those, it sounds like to me, is where the gap, the 10% would be, because it is mandatory as part of the new officer basic course. And that was my understanding, because I used to teach a portion of that in relation to domestic violence issues at the solicitor's office, and oftentimes our programming was right around the same time as the CIT training.
Okay, so the CIT training is required for
So
ACCPD.
CIT training, in my understanding, and you could confirm this with Chief Spruill, I'm sure, I believe it is mandatory for everyone who goes through new officer basic, and every officer they hire, even if they have experience in another jurisdiction, they are required to go through that, what they call NOBIC class, that has a variety of components. And it's very classroom-based, leading into a field training situation where they have an officer with them who has some seniority before they're just out on their own.
Okay.
So I believe it is already mandatory. Now and I think it's Officer Cochran and Ms. McFarland that are doing that advanced CIT training. I believe so. It's a curriculum they've made up on their own. That, to me, would be huge as well. Because when I was a public defender, I realized very quickly a lot of my clients had severe and persistent mental health issues, and I wasn't equipped to help them. Back then, the public defender's office didn't have a social worker. Luckily, they have a social worker now. That's a huge benefit for the public defender's office. But having that front-end contact by officers who are better trained can lead to better decisions as well.
Definitely. So if we could verify that the CIT is, and then if we can also look into see if it's possible that this further training that we're doing, if there's a way that we can set a goal a few years ahead of now that we have that also required for all officers. And then the other item that I wanted to bring up was getting back, this is going to be tied in a little bit to our last thing on our work session, but the inmate labor program that we used to the corrections facility. I know the corrections facility didn't really come up much during the presentation. But putting a plan in place where we can actually have a compensation system for all those inmate laborers, as I threw out in the retreat, getting to the point where we're at $4 a day, which I think is something that the county could do and work up to. So that's also something I would like to explore.
Any others? All right, so we got a good slate and a lot of great work underway already. TJ, I really appreciate you putting this together. Judge Hope and everybody else, thanks for coming down tonight. Thank you. Good work.
Thank you.
Would folks like to take 5 minutes while we're getting set up for the next one? All right, make it quick.
Did you bring any snacks? Do
you want some of these things?
I got some
Medication.
Gonna roll. All right, y'all, we are fortunate to have Jeff Hale here from Human Resources to talk about the Comprehensive Classification and Compensation Study.
Thank you, sir. Appreciate the opportunity to speak with you all this evening. I'm Jeff Hale. I'm the Human Resources Director. Been with the government about 11 years and the HR Director for about a year and a half so far. We're going to talk tonight a little bit about the Comprehensive Classification and Compensation Study, affectionately known as the PAY study. So you'll hear me refer to it that way because it's a little bit shorter. So we're going to talk a little bit about some context for the study, the goals, how we went about it, the findings, and what the next steps will be. Just as a little bit of context for you, when we administer pay in the unified government for our employees, we have goals of recruit, retain, and reward. That's what our philosophy is. And in pursuit of those, we have a number of different kinds of increases that come up every year during the budget process. One is a recruitment tool which is aimed at the bottom of our pay ranges to make sure that we're competitive with the market. And we typically do some wage survey around that on a yearly basis. We also have market increases, which, as you know, we can raise the minimums, but the price of things still go up. And so we try to keep our pay current with cost. And then we also have a third component of pay increases, which are pay for performance. That's the primary way that folks really advance from the minimum of a range and through the range. And it takes all three of these to really maintain a classification and compensation system. If you do something for incoming employees, but you don't pay for performance, then you lose the engagement of the workforce. If you don't do market increases, but do pay for performance, that performance reward is wiped out by the price of milk. So those are the main components. Just a brief history, and there's a graph here that just sort of shows pre-recession, post-recession kind of look. And you can see that over time, we've been in that 2.5 to 4 or 5% with a merit pay component pretty consistently. We hit the recessionary years, and just like everybody else in the world, our ability to meet those kinds of goals was attenuated. The good news is this government did a spectacular job of taking care of employees, and there's a recovery period that happened, and so people sort of waited that out. And since then, you can see both the frequency of pay increases for merit and the sort of size, relative size of the increases have gone down. Certainly after the recession, there were probably lots of competing needs and pent-up demand for all kinds of services and programs that hadn't been watered. And we've only done a merit pay increase for twice in the last, as you can see, 9 years or so. That is a backdrop for our approach to the pay study. And you can see just some very rough numbers, pre-recession versus post, the investment in the compensation system. And when this starts to happen, if you don't maintain those three components of pay, you get a number of side effects. Pay compression, which is simply, there are different kinds of it, but you can imagine people hired over the last 10 years, if there aren't sufficient ways to move through the range, you have people clustered around the minimum of the pay range. So a 1-year employee's pay looks like a 5-year employee's pay looks like a 10-year employee's pay. So they're all kind of traffic jammed up against the minimum rate. They're not advancing through the pay ranges, and that's inequitable. We get recruitment challenges, difficulty hiring folks if the pay table is not keeping up with the market. And that gets exacerbated, particularly the last 18 months with historically low unemployment. People have options. It becomes difficult to get a traffic engineer, an attorney, a water reclamation operator, a police officer, and so on. And that has a real impact on services, overtime, morale. All that said, we were tasked with a class and comp study, which I would describe as an impersonal look at positions. In the same way that someone comes out to assess your property, they look at the things that drive the value of your property, but they don't talk to you and gauge what kind of person you are or your efforts. They're simply looking at the value of property. And so our task was to do a similar evaluation of positions. So when we look at positions, we look at the things that drive the value of work, and we provide a valuation for the position. We also want to use objective methods to do that. We want to be in legal compliance when we do that. And we want to be able to explain to you and everyone else, why are we paying the salary for that water reclamation operator that we are? It needs to have a rational basis. So that being said, against the backdrop of some of the less than consistent pay maintenance, people tend to place their hopes and their dreams on a pay study, thinking that it's going to be sort of a true up for the recessionary years, for maybe missed performance increases, and a lot of expectations get misplaced onto a pay study. This is an impersonal exercise. Pay is extraordinarily personal. And so these kinds of studies are invariably disruptive. There are winners and there are losers in the sense that there's not an across-the-board increase for people. This is evaluation of positions, and then it's coming up with a new structure to place those positions in based on the market data, and then it's transferring our employees from the old system to the new. Get them relatively where they belong, and then move back to regular pay practices of market, ECI or pay table, and performance. Yeah. Thank you, Tom. Tom's performing ventriloquism. So we have a classification system, and this is sort of the primary organization of our pay system. It's mandated by ordinance, and it is simply a way of organizing our positions into groups of like work so that when we assign them to a pay range, a senior police officer, a senior deputy are in the same pay range and paid equitably for the same work. So jobs that have similar educational requirements, experience requirements, exposure to hazards, knowledge, skills, and experience, those are all placed together and then paid similarly. So the goal here is consistency and equity in pay. And over time, if you don't sort of rebalance the system, we have inequity. Jobs change, technology changes, services are added, services go away. And so we need to make sure that we're valuing our positions correctly. So fortunately, Mayor Commission was gracious enough to authorize a study. We engaged management advisory group to help us with an independent and expert review of our system and some deliverables. And so these are the things that we were setting out to accomplish. We wanted to make sure that our positions are competitive with the market. So can we get that traffic engineer in the door? Are we paying comparable to other like agencies or employers? And the deliverable for that is MAG would construct a new set of pay grades to match the market to help us pay competitively. The second piece of that is to then look inside the organization and make sure positions are relatively aligned with each other, that they're ranked with each other where they belong in the hierarchy. And so those are really the two goals. And the deliverable for that is that once you have that new structure, you place positions into pay grades where they belong, and then you transfer the people in there where they belong relatively. And then, of course, we're engaged in updating some 400 job descriptions in the wake of this. Now, what you're going to see here is what this study is not designed to do. And the reason I share this with you is because it's really representative of some misperceptions and some disappointment that people who weren't happy may express. So it was not a way to give people across-the-board raises. Y'all do that through the budget process. If you've got a traffic jam and you move everybody 5 cars ahead, you still have a traffic jam. So giving everybody across the board raises might give them more money, but it doesn't fix the inequities of having 1, 3, 5, 10-year employees all clustered around the minimum. You have to do more than that. You have to do it differently. And so this is not across the board. You can't address all the past pay decisions or practices. And the last time a study like this was done was 1994. So a lot of water has gone under the bridge, and I can't help somebody with the fact that 10 years ago they were hired at what they think was too low a rate. I can't undo that. This is a transition from an old system to a modern or updated system, and then forward we go ahead and administer pay in a more consistent way. It's not going to address the recessionary years. We would love to true up with people with what funds we couldn't muster during those times, but neither can most organizations like us. So that's just simply something we can't do. And the other thing that we struggled with is this is not an exercise in valuing the people and their performance. Again, that's a merit pay issue, and that was not a part of this. And so in the wake of the study, if I want to compare my increase with someone else's, if I'm making a value judgment about someone else's performance, that's misplaced. So we'll talk about how we did this and what the implications are. So MAG helped us collect basically 3 forms of data to synthesize in order to place positions where they go in a new structure. First thing that they did was survey the market, and we had a list of comparable agencies like Athens-Clarke County that could be considered competitors or comparable agencies, municipalities, communities. And we surveyed those agencies with a benchmark number of positions. And MAG developed the orange line, which is the linear average of the midpoints of all the pay grades of those positions compared to ours. So that is an overall market line for all our positions. And those numbers at the bottom represent the old pay grade structure, pay grade 8 through 43. And you can see that if you look at the blue line, those are our midpoints for the same pay grades. And we track pretty well to a certain point, and then the market starts to go away. And we find that basically an average of about 4 to 6%, we're off the market, which considering 20 years without a study, that's pretty good. So the relative cost of this compared to what we might have expected was lower than we had anticipated in terms of fixing that.
This midpoint, that's the midpoint in the salary range. It's not the midpoint of salaries being paid. Is that right?
That's correct. The midpoint of the range.
Right. So, okay.
For the blue line.
Right.
Yes, sir. So MAG took this data and they constructed a new set of pay grades for us. And what that looks like, it's in your appendices, but essentially it's not linear anymore. There's a curve as you get out there to that, what was old 20 or 21. The whole curve is shifted up to represent the fact that the market has gotten away from us a bit. There are fewer pay grades now because MAG shared with us that we didn't have enough differentiation among the types of work to justify 43 pay grades. So we have a brand new structure. So that's the first deliverable that we got. The next thing we had to do is learn about what employees do and thereby try to place them in the right pay grade. So we're starting over and we're taking people and putting them from the old structure to the new. And we ask every single employee, what do you do in terms of your data responsibility, your judgment, and all of those dimensions of work that you see up there. This is a MAG proprietary instrument. And it in fact has a point factor system that does something called whole job ranking, which ranks every position against every other based on the quantitative data that comes in. Every employee had the opportunity to fill this out. If they had difficulty, they could do it in groups, so you could have a group of bus drivers or police officers who do substantively the same thing together. And they produced these questionnaires which provided quantitative data for MAG to have as a reference point to start placing positions. And then the data for that and the market data are not quite enough, because we need to know to some extent how do those jobs work, function, relate in our structure here in Athens, Georgia. And so there was a iterative process where MAG would place jobs in pay grades. HR would do a technical review of that. We would get some feedback from department directors, and then MAG and HR would go back and forth to try to sort of broker that. And ultimately, MAG synthesizes the market data, some of their own database and experience and studies. They look at our JAQ data, and then finally they consider this more qualitative feedback that helps inform them about the organization. They were able to then finalize pay plans, two of them, one for the unified employees that are non-public safety, and then we pulled all the public safety into a separate pay plan with a separate grade structure. So we had to map all of those ranks and line them up in a separate pay plan. And that's a big step, I think, that will pay dividends down the road. The MAG final report came in December. In October, we were able to notify employees based on the completed pay plans what their projected salary would be. And then we just implemented this in January of 2019, where we transferred everyone over from the old system to the new, and they realized the full impact of their pay adjustments in that January check, and will for the remainder of the year. And then we'll find a way, hopefully, in the ongoing budget process to pay for the whole of the adjustments across the 2 fiscal years. So let's talk about the pay adjustments real quickly. There are 2 types of adjustments people may have received. They could have received one, the other, both, or neither. And so the first step is, once we assign positions to a pay grade and we start to fill those positions with the people, they have a current salary, and we want to compare that to the new minimum, and if they're below that new minimum, we're going to adjust them up. And so we did that across the government. Everyone moved up to the new minimums. If they were already above the minimum, then they transferred their salary. But that's not enough, because when we move a bunch of people up, we start to exacerbate that traffic jam of people getting, so we have to do something else. And so we had a second round of adjustments that we had to figure out. And we call them equity adjustments with the funds that were remaining. And when we did that, we wanted to make sure we had a uniform, equitable approach where we treated everyone equally and fairly with those funds. And so the only really valid criteria that are common to all employees in terms of some further valuation of their position is their time in their current position, which is really a best practice because that's the work they're doing right now, and that's what we're trying to value. But you can also use time since hire, which to some degree overpays work they may have done in the past that they're not doing now. Nevertheless, I think as an organization, we value people's commitment, we value their institutional knowledge, and we value how their prior work with ACC informs their current job. And so there's a decision made, one, because when we modeled data down to the individual, we could look at an outlier and say, that's Joe Johnson there, or Jeff Hale. And when we looked at that, we tried to make sure that we mitigated any outcomes that weren't, great. And the fact of the matter is, this is a formula that we had to apply to everyone, all 1,600 employees, regardless of their particular circumstances. And in some cases, that's going to create some outliers or some issues. There's just no single formula that's going to account for all circumstances. And when we did that, we came up with an experience credit to give people in order to place them further into their pay range than where they were, and thereby create some of that spread among people and alleviate some of that compression. Some of those people should have moved through the range, and that didn't happen because of some of the lack of the maintenance of the system. And so when we did that, with MAG's help, 100% of time and position, which is the most valid, best practice way to value experience, we gave them credit for that. And then we gave them a 40% credit for any years prior to their current position with ACC Gov. And then we placed that in the context of their new pay grade, and we calculated a target salary and compared it to what they were making. So that doesn't help you much. Let's look at an example. So again, we've moved everybody into their pay grades. We've assigned them up to the minimum at least. And now we're looking at, can we do something further to spread them apart? So $51,000 is a salary. They were hired 10 years ago, promoted 5 years ago. So 5 years in position at 100% gives you 5 years, and 40% of the 5 years of prior service is 2 years. You get a credit of 7 years. We go down into the graph. We start at 0 and the minimum of the range, and we go to the right out 7 years, and we go up to their current salary, and that blue dot is the current salary, and it is above the target line, and that target line is essentially it's a new floor for trying to place people within their range. And so this person doesn't receive an adjustment, they're already at or above.
Would you tell me what the target pay line is again? Is that the minimum or the midpoint, or what is it?
The target line represents really it's the for every, say, year of experience, there's a percentage associated in pay that you go up in the range. And so it's really just it's the slope of the line.
Okay.
And so that created a way for us to calculate further valuation of people's experience. Now, it has implications. You can imagine that a person who is in the same position with the ACC Go for a long time will get a higher adjustment than maybe somebody who has come in and promoted quickly and not been here very long. That is a consequence. And the reason for that is that we have to use these objective criteria. There really aren't others. This was the best fit. And this is not the way to pay people. This is a way to transition from one system to another and alleviate some of the issues that have obtained. Once we place people going forward, the opportunity to reward people, to move their salaries upward is a function of budget and pay increases that may be available. So an example where someone received a pay adjustment is a $52,000 salary, 15 years in their current position, and 2 years prior to that, or excuse me, 5 years prior to that, they get 40%. So their experience is a 17-year experience credit. And again, this was applied to every single employee the same way. And the reason being that that is an equitable, defensible, uniform way to do this without creating challenges, essentially. Yes, sir.
How did you guys come up with the 40% for prior years served in a different position?
It's a good question. And so, one reason is that you want to weight the experience in the current job more heavily. The other is that simply when you start to run the numbers and you model the various consequences, you have the fewest number of inequitable outcomes at that point. It's a fit.
I asked that question realizing this was very difficult, but yeah, I'm just trying to get to clarification.
Yeah, if you want to.
Yeah.
I'm Tom Quist, I'm the Compensation and Payroll Administrator, and I did a fair amount of modeling of the data as we kind of worked through and really kind of had to explore, are current situation. There's no magic number necessarily, but so there was kind of three routes we could have gone using the two factors. We had time and position, we had overall time with the organization. A lot of places use a combination of those two, but one thing we considered was actually only using time and position. The problem there is because our pay grades overlap, somebody who had, as Jeff had mentioned earlier, someone who had recently promoted, they could have been here for 20 years and recently promoted and lost all prior credit, so they wouldn't have moved up within their range. Someone who was hired at the same time, I'm sorry if I'm getting a little confusing here, but someone who was hired at the same time and this person who just promoted in their prior position, if they didn't promote, they might have moved past them. Yeah. So you had like a rank or hierarchical inversion resulting from the time and position. So we knew that wasn't acceptable. Understanding, again, as Jeff mentioned, you got to be equitable, you got to be consistent, you have to use one formula, you can't pick and choose the winners, you've got to find something that fits the organization as a whole. So the alternative to just using time and position was using overall time with the organization. Had we done that, you could have had two employees who were hired on the same day, one promoted after 5 years, the other one took 15 years to promote, and then we placed them at the same salary, even though, let's say, for example, two police officers were hired, one promoted to sergeant after 10 years, one promoted to sergeant after 20 years, just last year. So the more recent sergeant would get credit for all 20 years, even though they had only been a sergeant for one and the other had been a sergeant for 10. So we tried to find a balance where we kind of mixed all of that together, and quite frankly, we plugged in, we tried 30%, we tried 50%. We were just trying to find the best of both worlds where we didn't have lower level positions creeping up on the higher level positions, and so we maintained equity for time in position and time with the organization. It just so happened that 40% was the best fit. It provided the best kind of distribution of all those salaries. It could have been 39.5 was a little bit better, but ultimately 40 was a straightforward. It just seemed like the best fit. So, does that answer your question?
It does.
Sorry, I need like a whiteboard.
No,
next time.
You did well.
And so, our consultant was prepared for us to settle with one or the other, and we pushed back and got to this place instead. And so I think Tom deserves some credit for that as well. In this case, you see a 17-year credit. We move out, we go up to the current salary of $52,000. It is below the line. That red line represents an adjustment to the line. And so that's an equity adjustment that someone would have realized in those circumstances. That person may have been below the minimum and needed that adjustment, or just needed that adjustment. But that's how we applied, and that's how we placed people further into the range. And again, this is not the ideal way. This is a transition formula. It's a one-time thing, and that's how we accomplished that. So some key outcomes that I think are useful to consider. A lot of these efforts fail because they're too expensive to implement. And we were able to, through the managers, set aside of some funding and the Mayor and Commission's agreement with that to fund the initial effort fully for half a year. And again, that spreads the investment over 2 fiscal years. We saw 78% of employees receive some adjustment in pay upward. No one went down. That was a rule going in. We were not going to take pay regardless of valuation. And in some cases, when positions were valued lower than we thought, we asserted an institutional value where we said those positions are too important to us for a number of reasons, and gained agreement with MAG. So,
could you explain that first bullet for me, please?
Sure. So if we were to have implemented the pay study and given everyone their increases based on the money available in FY19 on July 1st of 19, we would have taken that, it was about $2.5 million, and that would have had to have been spread across 12 months. Well, that amount of money was really about half of what we needed to both move everyone up to the new minimums and to affect that spread, some degree of sufficient spread among employees so that we didn't make things worse by the study. So there were two steps, and the only way to do that was to fund it across 2 fiscal years. So instead of doing a watered-down 12-month version, we did a full implementation. So an employee got both their adjustment to minimum and their equity adjustment starting in January. So half the money funded half the year. And then in FY20, it's incumbent upon us to find the rest of the money to pay for it for the full 12 months going forward.
A different way of saying it is we had a little challenge in FY19 and we'll have a big challenge in FY20.
We funded 100% of the increase
For
in
half.
half the year.
Right.
And so we'll have to come forward with the other half to make it a full year implementation in this budget year.
But FY19, that starts July 1st of this year, but
Total
we,
cost of implementation is about 5.6 million.
okay,
And we had half of that last year, or this current year. So we waited to the 6-month mark, and we made the employees whole. Now, that pretty much forces, in this budget year to make the rest of it come through for a full 12 months.
okay, so the last half of fiscal year 2018,
2019.
2019.
January 2019, okay, our fiscal years are on the calendar year.
No.
No, July 1st.
July 1st of 18 starts
We're
fiscal year
in, we're in
19.
FY19.
So we're in the second half of FY19.
Right.
Okay.
We are currently funding the full adjustment for the latter half from January of this year through June.
Okay,
When that fiscal year draws down, we'll now owe people a 12-month version of their pay adjustments. So we only had 2.5 in FY19. We've committed that. That's an ongoing cost, and then we have to find an additional half to fund the full
12
adjustment over 12 months.
gotcha.
And
So in this next budget cycle, we will need to set aside 5.6 million.
Half of
Half of that.
Half that.
No.
Well,
All of that.
5.6
if you
comparative to
assume the
the year.
baseline budget is what FY19, you'll have to add to that another $2.5 million to get there.
Right.
But it will be 5.6 million in FY20 more than FY18 2 years prior.
Yeah.
I'm sorry, Patrick, go ahead.
So pretty much we are, I was gonna wait to the end, but to ask questions. So we pretty much borrowed or are borrowing the money? Explain, okay. So last July, the Mayor Commission voted for $2.5 million to be allocated to the pay and compensation study, correct? Implementation. And employees got their payroll increases, or some of the employees got their payroll increases in January.
All the employees that were due an increase received it in January at 100%,
At 100%.
or 50% of the year.
This part is confusing, but we're not paying the other 50% of the year, right?
No.
That's right, there's much
Okay.
gone.
Good, okay, just want to make sure, yeah.
Okay.
So
We decided to implement the program, not in baby steps, but all at once. And the only way to do that was to delay the implementation until the last half of the fiscal year, beginning in January.
So we've implemented the study for
Yes.
half of a year,
Yes.
for half the amount, 2.5 million.
Correct.
And we're about to develop our fiscal year 2020 budget, which will require 5.6 million,
Right.
more than what we
No,
implemented. 2.5 million.
Yes,
Because we've already done 2.5.
Right.
correct.
That's already been added to the baseline of the budget.
Absolutely.
Right.
So to do it for, and that was for 6 months. So now to do it for a full year, to bring it up to 5.6, we have to add another 2.5 to that already existing 2.5 to get us up to the full implementation for the
Correct.
fiscal year.
you got to pay for
All
the
right.
other 6 months.
Yep.
That's right.
And the wording in here on spread over and total investment of 2 fiscal years. So what are we saying there? That we're only doing this, making this house for 2 years?
No, it's ongoing costs.
Right, okay.
But the initial increases were taken in steps. We did half of it.
Okay, I see, that's what.
Yeah, that's.
All right, that's fine.
That's all.
Thanks.
A lot of these implementations fail, and this is part of the reason, is that the price tag is high, which is why I'm going to come back to where I started, which is that if you don't maintain the system when the bill comes due, it's challenging. And that's not to say that it would have been possible, but if it allows, you got to pay the light bill and the mortgage and everything else. Employees are what and who deliver the services. And this effort is really to make sure that what we're paying is on target.
What confuses me or concerns me is that we did a study on competitive salaries, and we used that to readjust our pay scale, right? Our
Yes, sir.
grades and pay scale. Then we did this exercise with time and job to adjust people. But we didn't adjust them reflecting on the competitive study. They're disconnected.
If
We could have done what you did without studying the competition.
Well, what would you have based the changes on?
Well, on the competitive study, the Gwinnett County's paying this much for a police officer with this rank and time in service, then we should pay that police officer that amount.
Well,
It's two different things.
Well, the other thing is, you've got external equity and you've got internal equity. And so it's one thing to say, the market's paying this in these jurisdictions, therefore we need to pay that. But then everybody else has a relationship with each other as to the duties that they perform. And so you want to make sure across the organization, you're starting to move this person arbitrarily over here and that one over there, but that doesn't reflect the internal equity that has to prevail. So that is a necessary second part of this.
it's a very complicated puzzle of taking
Yeah, I know.
those, And so if you,
Yeah, I know. But, I'm sure that there are some of our departments where, the average time, that most of the people are below the midpoint.
that's correct.
And, it makes you wonder what the midpoint means.
Well, in our particular approach, in our system, the way it's been administered, as far as I've known, the way to advance through the pay range is through performance. That is the mechanism for that. And if that's not funded, then people don't move.
Right. So I understand, what we did, but I don't understand exactly how it really achieved the goal. We've achieved this internal equity, but we have not brought our salaries up to be competitive.
We have.
And we haven't done too much with compression either.
Well, we are competitive, and we've got recent hires to prove it. We certainly would not have landed the police chief we have right now where we were 6-8 months ago. Wouldn't have been in the mix.
My read, Jerry, is that we did one and then we layered the other. I mean, that's my kind of perception of process. We did that kind of market-based equity, and then we provided through the formula that internal equity on top of that.
Well, the marketplace equity set our pay ranges, but it didn't set our pay. It didn't change our pay.
It did. It simply did.
Well, okay, so what, the formula that you just went through, is that how new pays were determined?
That was a second step.
That's a second adjustment that people may have
Okay.
been eligible for on top of a market adjustment. So if we needed to move people up to the new minimum, we did that. And then,
Right, I knew that.
based upon that, there was a certain amount of funding that remained that allowed us to
Okay, so
place people further in the range.
We moved them up to at least, we moved them up
It's a
to
new
the
floor.
minimum.
Yeah.
Right, and then we adjusted for time and grade.
Because I think out of 1,700 employees, there were 400 positions that were studied. And in one position, you might have 30 employees that are in there. And they've been here for different levels of time. I think some of the frustration came because there was some differentiation between employees because of some performance pay over the years. And this doesn't look at performance. As Jeff said, it's impersonal. It was just to bring that particular position up.
Yeah.
And now you've created some compression because you're starting to chew into some performance differentiation. And so the only way that we felt that we could do that fairly, and again, HR pushed back. The consultant wanted to do a one-dimensional look at that. And they tried to make it, and I think did successfully make it more, it mitigated more of some of those concerns. And so it was a second step once you change the positions.
So what we've achieved is that we have people relatively where they belong in the right pay grade and within that pay grade relative to each other to some degree. And some of the compression that exists, there's different types of it. It was there before, it's still there in some places, and there are reasons for that. But we are positioned in a way that we could address that going forward now. But this was a necessary step to get to that point. And to the extent that you want to further affect people's pay, we can do that. But we can do that in a way where we've level set, we've reset the system, we've updated some titles, we have a classification system that matches the market, and we have a refresh.
We just have to commit to performance increases from here on out.
Well, and it's really some combination of all three, understanding that in any given year, you may not be able to do all three. And perhaps in the coming year, the emphasis could be on performance since that was absent in this exercise. But those are policy decisions that
I've heard that maybe, and you'll know about this, that maybe the rankings in the police department weren't really appropriate for this study. That the study did not treat them equitably.
Well, first and foremost, I would say that this was not a study for the police department. It was a comprehensive system, and so we did not treat them differently other than we did find a way to move them into their own plans so that if that were operationally or for market conditions needed in the future, you could do that. You couldn't do that without first pulling them out. The second thing to realize is that when you have rank structures, and as Tom said, where you have overlapping pay, there's not a lot of difference. And so compression is going to be endemic to that kind of structure anyway. And to the extent that we could fix that, there's some things, say in police, where you have maybe additional titles in there that, by virtue of the structure, more ranks that exacerbate that problem. That's something I think that the chief will want to take a look at with us.
Okay.
So there's still work to be done, and I've continued to tell people this is a comma, not a period. We've engaged in this exercise, and we didn't undo 20 years of pay practices and decisions. It's simply not feasible, nor could we have with the resources. I mean, we did this limited exercise. We believe we've achieved a lot, but certainly there are places in the system where things need to be continually worked upon. And as we get away from the study, we own that, and we'll be working with department directors to address those things. This is not
That's encouraging.
We're not hitting a wall. No, sir.
Jeff, you mentioned here earlier previously we had 43 pay grades and that we'd lessened those. What's the number now that we're working with?
Well, we've broken into two different plans, and so it's less than 43.
Greater than 10.
Unified plan.
Unified plan.
Somewhere between 1 and 42, I'm guessing.
Yeah, it's probably in the neighborhood of 35 to 40 in that range.
Less than, I think.
Less.
I think there's 32 maybe in the
Well,
unified plan.
but
nobody's in pay grade 1. So.
Okay.
The lowest, I believe the lowest may be 4, and I think it goes up to 32 or 33 in the unified plan. And I'm sorry, this is on TV. As Jeff mentioned, there's 2 plans, so there actually in total could be more grades, but they sort of are alongside each other, not 43 spread out on top of each other.
Oops.
Does that make sense? You have 2 parallel grade systems, whereas before we just had 1.
Okay, what are the 2 parallel grade systems?
The unified and the public safety pay plan. So the police, the sheriff, the fire department, corrections, probation, they're all on the public safety pay plan. The remainder of the government is on the unified pay plan.
And we never had those broken out before.
That's correct.
You had a police sergeant in with a budget analyst, in with a program director. And so rank structures they're paramilitary, the nature of the work, the requirements for the work, all of that is so very different from the rest of our positions that it seemed like a good plan to separate them out. Now, that said, you've got, I think, 5 or 6 agencies in there. You've got fire, probation, police, sheriffs, corrections. That's it. This is sort of an overlay, and this shows you kind of the linear 43 grades with the new unified plan sort of overlaid on top. You can see the curve shifted up, so that represents that all the new minimums have moved up. It mimics the market difference that you saw in the initial linear version of the market survey data, and it compresses us down into fewer pay grades. See, that was pretty close. Look at there. So that's sort of what, and the public safety plan looks somewhat similar to that. It's not markedly different. But that's a new structure, and it's one that will serve us for some time.
Patrick, did you?
Yeah, that graph looked very top-heavy, but, so HR set the criteria, and you sent it to the M&G, M&G.
When you say set the criteria, tell me.
Like, let me go to my notes. Sorry.
We sent MAG all our data, all of our practices, all of our systems.
The equity adjustment. Did MAG set that? M&G?
MAG,
Okay.
yeah, MAG. This is all their study, and they're the ones that have to raise their right hand and defend this if it were to be challenged. They're the experts. We were in a middle sort of brokerage role to provide some technical oversight and project management and organizational or informational, institutional knowledge between the rest of the organization and the consultant in the effort.
So, example, if I worked in leisure services for 15, so the threshold was 12 years, correct, to get, or was it 15 years? Okay, I'm sorry, I'm about to fall asleep, but let me.
It's okay. This stuff will do that to you.
Equity adjustment, time and position on values or work employees doing. What was the basic threshold? So you could have been in that position for 5 years, correct, and you would have got a market. Okay, so what's the formula for that?
The adjustments were done this way.
Okay.
Once we took you from, if you look up at the chart, so if you were in the old pay grade 18, and based on market data and based on the JAQ, the job analysis questionnaire that employees filled out and the data associated with that, based on organizational relationships and qualitative information and MAG's expertise, they may have placed your leisure services job from 18 into 121 in the new structure. There's no relationship there other than that's where it belongs in the new system. Now, once we place your job there, we look at your salary, and are you at least at the minimum of the new range we've put you in? If not, we move you up. And then we apply the formula that you're referencing based on time and position and time with the government. And we may apply an additional adjustment depending on how that works out. If you're above your target salary already based on those criteria, we leave you alone where you are. If you're below your target salary, we move you up to the line and you get an additional adjustment within that range. And that provides a way to make sure that we don't make a bad problem worse.
But to address your concern, we took each individual employee's number of days that they've been with us.
Down to the day.
Down to the day. And that's how we placed them. They didn't have to meet a criteria of how long they have been here. It was based on every single day that they've been here, or every single day that they've been in their position.
So,
thank you, Laura.
So, like, if they got 5 merit raises in 5 years, and they were still below market rate, they did not get the market rate new pay, correct?
Yes. Yeah, they did.
Yes.
Let me explain this a different way if I might.
Okay.
Sure.
All right, so let's say a program specialist in leisure services. Let's say there's 10 of those people, okay? And let's go through this and let's assume that none of their salaries met the new minimums. So all 10 of those employees are moved up to the minimum as a first step. But the problem is, of those 10 people, you've been here 3 years longer than I have, but we're making the exact same amount of money. And so then they came up with this equity adjustment to try to bring some separation, because that's called compression. When you got everybody right there together, you got to start spreading them out. And so the second adjustment was based on time and position and time with the government as they gone through. And what that enabled them to do was start to spread those 10 people out from each other.
And
But
that's,
it didn't take performance into account. And in the last 9 years, we've only had 2 performance increases anyway. So now you're talking about performance increases that were given years ago that are now kind of being wiped out because we're transitioning to the new plan. And that's where you heard a lot of frustration, at least I did.
and so, again, those differences should have theoretically already been there based on time and position and ongoing increases and merit increases. If they didn't happen, people started to stagnate together. In this transition, there was opportunity to at least address that to the degree possible, given the funds we had. And the formula was the way to do that in a uniform way so that everyone had the same formula applied to them. It had a different outcome depending on their factual circumstances, but that was the way to try to value jobs further beyond the market study.
Jeff, let me try to help out a little more about compression. And one of the big ways compression occurs is you start someone in a job 10 years ago, and maybe they've gotten a little raise. But now, in order to hire somebody else for the same responsibility, the market is such you're going to hire somebody new for more money than that guy who's been here for 10 years is making. So now you've got inequity and compression. That's a big problem. It happens all the time. I've faced it a lot.
Yes, sir. Thank you.
And so that this formula that he has helps adjust for that. It rewards you for time and grade. Potentially.
Just a few quick questions. Do we have this same chart for the new public safety plan?
We do, and we can provide that to you.
Would love to see that because I didn't see it in here.
Absolutely.
And then a couple others. So we have 78% of employees receive raises, so 22% did not. On that,
can we use adjustment and not raise? Just
went from Chappie. On that chart, if we can go.
Oh, I'm sorry.
Oh, okay.
Back to the chart.
Yeah. I forgot. I don't know how much you're, but like of the 22% who didn't get raises, like what pay grades were they in? Or didn't get adjustments? What pay grades were they in?
It would have been based on.
Was it very? I guess
there wasn't a if you're looking.
There
for
wasn't a pattern.
to
Okay.
it,
There wasn't a pattern. Okay.
No. Because of the fact that the market is what it is, and the adjustments are uniformly applied based on the market, and then this formula was uniformly applied, and so.
I just want to make sure because of some of our past history of actions that it didn't lead to a pattern.
Sure.
Okay.
Sure.
And the last question, how many people what percentage did we have below the minimum? Just to know how off we were going into this.
We'd have to get you that number.
Okay. I'd love to be able to see that.
We'll get you
though.
that number.
Yeah.
So ultimately, roughly the $5.2 million in adjustments to employee pay, that's going to impact their families and help with retention. This is a big step in alleviating recruitment challenges. We are, all of a sudden, the directors who were sort of hitting us with every hire with an above minimum request, that has ceased, and that's a good sign. I don't have data on recruitment yet, but certainly anecdotally we're seeing a difference. We reset this very complex system. It's a Rubik's Cube, and you pull one or you pull one thread and the whole thing can come apart. It's very complex. It took a lot of work. we have 2 separate pay plans, and then we've actually implemented a pay study, which is no small feat. We had a great revenue year that allowed the funding. We had a mayor and commission who were willing to let us engage in this. And then we had, really frankly, an organization-wide effort and a decision to fund full adjustments for half a year to sort of finance this. It's really impressive, and I'm proud.
And I'd like to add to that, Jeff. That's a reason why a lot of organizations shy away from this. And the longer you wait, the more uncertain it becomes. Because how bad would it be if you went through this entire, you've asked every employee to fill out job descriptions, you're talking about a pay plan, and you can't afford to do it? It hurts morale. Secondly, as Jeff said earlier, it's inherently disruptive. It's impersonal. And I'm not sure I've ever, and this is why organizations shy away from it, because it makes some people upset along the way when you try to change from one to the other. The solution is every 5 years you relook at it. Don't let it go so long again. And you continue to fund pay for performance. So maybe I'm getting ahead of you.
You continue to really, well, let's just, thank you, sir. You really need to be consistent across those 3 types of pay to maintain the system. Performance pay is particularly important to allow people to move through the range. And as you said, sir, I think it was like 12% we're at the midpoint. That's not terribly unusual, but nevertheless, for the center to hold, you really have to pay attention to all of this. And we'll continue to do work on policies and procedures. There's no way that this was a perfect effort. There are places that, we'll continue to address with career ladder opportunities, with perhaps changes in rank structure. There may be opportunities for this body to look at public safety or other aspects. But we're going to continue to collaborate on this stuff, and it's never ending.
This is the last question. This is, I guess, to Blaine also, anybody. It seems like some of the concerns that we've had were just like maybe not foreseeing the need for as much transparency or engagement with employees. So they had an understanding of what, like I liked your statement, this was a comma, not a period, but it seemed like there was some misunderstanding about that. And so do y'all feel like that we are successfully alleviating those fears with better communication to all of our employees so they understand what this study was about and what's going to be happening moving forward?
I would admit, I think we, in trying to make this happen with the workload and resources we had and syncing this up with the budget and the calendar and all the moving pieces, we did create video, we did create opportunities to meet with leadership in each department and ask them to go out and share a presentation with their employees. Message sent is not message received. You can imagine the challenges of explaining this in short order and the emotion that people feel and react. So there's been a period where people have reacted emotionally to this and wanted to fault. And where there were things that were not ideal, we saw those things, we anticipated them. I don't think we've been surprised by any feedback, but we also recognize that I think where there may be some suboptimal outcomes, the alternatives were far worse. And that's a difficult thing to try to share with people who want to, and frankly, looking at those pay adjustments, they have the perception that this was a true up that was coming. And so can we do better? Yeah, I think we can. And I think we can continue to hit that note going forward.
Well, Mr. Hale, what you didn't do was let perfection stand in the way of progress.
I hope that's true. And I had to fight Tom on that tooth and nail at times. I admit to not being the perfectionist and being pragmatic, but it made for a good work effort. And I want to also introduce Laura Welch, if you've not met her. She's the assistant director. And I think the 3 of us have kind of been up front in trying to assuage the concerns and recognizing the disappointments and absorbing a lot of that. And our directors have done a great job of intervening and trying to explain. But, in talking with people, sometimes the best advice about a pay study is don't.
Yeah.
Is what I've heard. But that's not who we are.
And so at the end of the day, we have an up-to-date pay system. We, in effect, the mayor and commission have conveyed $5.6 million in adjustments to make our pay more market competitive. And not one employee lost any money in this deal. That was never the intention. And so I think it's all very positive, even though some folks may not have fully understood what happened. There may have been some suboptimal outcomes here and there. But it's a pretty Herculean effort to move to that whole new pay study.
Yeah, and I just want to clarify, like, I mean, I think it sounds like you guys did a great job. I think I have a better understanding now of this.
Yes.
And so it's a lot of that's because this is so complicated and a Herculean effort. So yeah, I'm just hoping that we can continue over these next few months to try to educate all the employees maybe had some of those concerns even more so they can have a full understanding of this. And also, this isn't the end of this. Like,
Right.
we're going to be going through these other ways. So I mean, we're going to take care of our employees. Just want to make sure they all feel that.
And let me say this, and I don't know how this might be received, but there's also a balance between continuing to try to help people understand versus, in some cases, a willingness to hear, and also in continuing to stir the discontent. I think to the extent that we can focus on what may be coming, what is coming down the road, what we're going to continue to do, I think that's a positive way to move forward, and we'll look into that. Thank you.
Thank you.
Yes, sir.
I've got snacks.
Really?
I've got snacks.
Really?
Oh my God.
I've got a daffodil cookie for you guys.
Oh, boy.
God bless you.
We decided to create some daffodil cookies.
Pass 'em around.
We
Thank
need
you.
Bring them around.
Wait,
Don't tease
did
us.
you bring 10? That
Don't
means
tease
each of
us.
us gets
I
2?
brought you two. I feel like I need to, get everybody in the room because there's so many of you guys not here, but if somebody wants to, or I can.
Well, let's send them around here a few times, please.
Yeah, start over here.
Fantastic. And we appreciate you guys making the daffodil the flower of Athens.
Oh, there's a lot.
Very appropriate. You know the mint.
This is Mayor Pro Tem's turn.
So you're the first department head to have brought snacks tonight, Suki, so, you know, I just want to let you know.
Well, that's actually, because I
That's
was
a
late,
bump on the
A,
system.
so you guys, thank you for being flexible. Actually, that was planned. It's not like I can pick up daffodil cookies on the, on the fly, so that was planned to thank you guys ahead of time.
See that?
Yes, no, I'm
And one
ready.
is for Jean, because Jean called today and wants some more
Jean got one.
daffodils so she can see them outside her office.
Gene got one.
All right. Blake, Mayor Gertz, you guys, are you ready or nope?
Nope, we're very lucky to have Suki Janssen, President of County Club.
Yeah. And thank you guys, and I apologize. We were asked to speak in South Carolina. South Carolina's going to open charms around the state, and we're curious about how ours operated. So we went there today to present about how our charm started, and the funding, et cetera. So I apologize about my tardiness from coming back.
So you were charming them.
I was trying to charm them, yes. We're excited for them. South Carolina has really great state support for solid waste reduction activities, and we are jealous. So I just wanted to update you guys, especially since so many of you are new, about what's going to go on downtown and what some of the items that have already gone on downtown behind the scenes with garbage. Some of you may not pay as much attention to garbage as we do in our department. Tonight I'm just going to go over the purpose real quickly, the history, what we've done so far, current approach, some of our options that we have piloted or will be piloting, and then some of the next steps. Tonight I'm just updating you on what's going to go on in the Central Business District with the pilot. We're going to try to pick up trash differently. To date, we have been in front of you a tremendous number of times talking about garbage downtown. Who knew? People were so passionate about how we put it out, what it looks like, and how we pick it up, and then how we take it away. But that's what we've done through the years to let you know about how garbage is handled downtown. The current method, I hope you guys are familiar with. In the Central Business District, we went to what was termed continuous service, but that was actually not accurate. It's enhanced service. We pick up trash from 2 in the afternoon till about 6 o'clock in the morning. And that's how often we're downtown just picking up trash. That doesn't include litter teching or sidewalk scrubbing. These are just our collectors. We have 2 daytime collectors from 2 to 10:30, and we have 2 to 3 nighttime collectors from 10:30 to about 7 once they get all the trash emptied, recycling emptied, and their trucks cleaned. So we have the 3 collectors from Thursday, Friday, and Saturday nights. Those are our busiest nights downtown. You can see the shifts there. And some locations downtown do have the ability for containers or roll carts, and we have started using those more, even with Chick-fil-A. Chick-fil-A is producing a tremendous amount of garbage downtown as well, so we have given them roll carts downtown. Nighttime produces about 3 times more trash than daytime, the 2 o'clock to 10:30 shift. So nighttime presents a lot more challenges than daytime pickup. Do you have a question?
No, I just wolfed that cookie down. I'm so sorry.
So what we proposed a while back, and we have been researching these and trying to figure out, because there are kinks with anything downtown. We don't have great alleys. We don't have very many alleys. We don't have very many nooks and crannies. But what we'd like to do are eco stations. In some communities, they have eco stations with roll carts. The top one is in Asheville. Some of these are around Knoxville. Some of them were pilots. The one with the planted wall was a pilot. So there are different public art and transformative walls can be incorporated into the eco stations. Roll carts are a little harder because there's not as much capacity and there's more manual labor to pick them up and drag the roll cart to the back of the truck. And there could be issues with roll carts being stray and left behind and outside the eco station. Clearly, we don't have any system where, other than people's words, to leave them in the station. So that's one concern we've had with roll carts. But we did try roll carts this past fall, and I wanted to share with you, and it was mainly at night. What we did for 3 games, October 6th, November 10th, and November 17th, staff went downtown Friday afternoon, delivered 40 96-gallon roll carts to the locations on the screen: Little Italy, Cutter's Pub, All Good, General Beauregard's, Boar's Head, and Silver Dollar. I'm giving you the bars because the reality is they're the high producers of nighttime garbage, especially on game weekends, and recyclables. What the staff did was ask all those locations, not just those bars or restaurants, but all the locations that surround there and produce recycling and garbage, to place them in the roll carts and place the roll carts out on the curb. And then use them for Friday night and Saturday night, busy nights for a game weekend. We didn't tell a lot of people we were choosing those games, and we did that with intention. Our results, we collected over 8,000 pounds of trash and over 5,000 pounds of recycling for each of those games, which is common. This is not out of the ordinary. It wasn't any more than past years. Customers appreciated the carts. The carts didn't disappear. We came out with 40 96-gallon roll carts when we picked them up on Sunday. The key is we didn't leave them down there. We don't have enclosures currently, and we don't want the carts out in the streets or to becoming trash as well, visual litter, or people rolling them somewhere they shouldn't. But just some anecdotal evidence that it worked as police department. We hadn't even told Blaine, which I shouldn't tell you guys this, that we were doing it these 3 games, and Aubrey Epps went up to Blaine and said how great downtown looked after these games. And Blaine passed that on to Justin, and Justin said, I don't know what you're doing down there, but it's been complimented already. And we had several other compliments come in, but we were trying to see if we could do it kind of so people could subtly notice some of the changes. Some of the biggest, in my department, I've got great staff, I get a lot of compliments, but some of the biggest and some of the most profound criticism has come from downtown. The most memorable was in the last 6 months. We had a visitor from Appling County. I can't remember if the letter came in through Gene or Jeff Montgomery, but she was appalled having to walk by trash bags on the street to get to her evening location for dinner, and just thought highly of Athens, loves Athens, but just thought it was such a backwards way to pick up garbage. I ended up calling her and talking to her. She was awesome. She was willing to come and speak to you guys on our behalf. She's really passionate and wants to see things changed. But it's hard talking about that when we do know there are other options in other communities that do work. And so that's what we're trying to accomplish here. Eco-stations with dumpsters is something else. This is what staff really would prefer to use because we feel like roll carts, they could be problematical. We don't have enough staff to pick them up on Friday evenings and deliver them, pick them up on Sunday evenings and deliver them on Friday. We don't have staff to do that on a regular basis, just for that pilot for those 3 game weekends. So roll carts could stay down there and be enclosed, attractively enclosed, and we could have a more flexible schedule to pick up, and we could use our front-end loaders to pick them up and not have to have additional staffing, those mini packers going around collecting garbage from 2 o'clock in the afternoon till 6 in the morning. That could cut down on costs for well over $250,000. We have 5 staff members downtown. We could reduce that down to 1 dedicated full-time staff and 1 part-time to make sure those enclosures are cleaned. So we feel like we could really save our ratepayers downtown by moving towards an enclosure that has communal dumpsters or containers. So what we did, we purchased the containers. The containers came in a little bit later, had some issues. They were made in Georgia. We were proud of the fact we found recycled content containers that came highly recommended, and they're made down in Greene County. Those are the pictures of the containers that we did purchase. We purchased 8 yards, 6 yards, and 4 yards so that we could have some variety in case the pilot started and we needed more capacity. What we're trying to do is we're close to finalizing our 3 to 4 locations on Clayton Street. What we'd like to do is pilot that just on Clayton. Clayton is the most troubling and high volume street for trash downtown. And so if we can do it on Clayton, we can actually roll some dumpsters in other areas and really do it anywhere. Clayton is the biggest challenge downtown for nighttime garbage and recycling in particular. So we purchased 16 dumpsters. They're here, 8 green ones for recycling, 8 blue ones for trash. They are recycled content, and they cost about $10,000. That's the cost of this pilot, because we're going to use our current staff for the pilot. And what we'd like to do is do the pilot. We had one hiccup, and that's what we're trying to work out is residential customers downtown. We have mechanisms to lock those dumpsters. Having that many keys for all of our residential units is problematic. If we did this permanently, we wouldn't have to have regular keys, but we could have swiper cards and a lot easier mechanisms to get into the containers. Through a pilot, we don't have that kind of capital because if this doesn't work, we don't have those mechanisms in place. So that's one of the challenges. We've been talking to some of our residential customers downtown to try to troubleshoot how we can work out dumpsters with our residential customers, but still keep the dumpsters locked to prohibit access from anybody coming downtown and dumping.
Are we locking the eco station that contains the dumpster?
We would if they went in permanently, yes.
So
there would be
it'd be
some
like
sort of keypad. In other locations, they either have a code that you would
Yeah.
put in, and that we like the coded system
Yeah.
because then we know, like Angora would be a specific code. General Beauregard's might be another code.
Right.
And in some systems, you can tell how many people are going in there. And what we have learned from other communities is if they had an illegal dumping issue, they can almost narrow it down to at least who was in there at that time.
And change
it's not
the code.
foolproof. And they could end up changing the code too if they had somebody that was abusing the area. So there would be a lot of benefits in having codes that were specific to a business or to a resident. A lot of places, though, also use swipers, like plastic swipers that you place up and will open a gate. So that's the cheaper version than the pad with the key into the number or numerical entry.
Well, I know, like, for the pilot, you could get a Schlage keypad for $120 probably, instead of having to make all those keys and handing them out.
I will tell staff is working on that. I like that. So they might have to, and we have Corey Jones has been great in trying to work with it, but our residential customers have really become a little more problematic than we thought. So
Yeah.
there's just so many, and they they sit out just about any time, whereas the businesses are fairly predictable on when they put out their garbage. Residential units aren't as predictable as businesses are downtown.
And with the keypad, you don't have to replace cards when they're lost or.
Or get the call from our residential, because we were going to give key people keys that can open them up and can come and troubleshoot and have our litter techs as backups. We're downtown 24/7. Between our litter techs and our collectors, there's not a time that there's not solid waste workers downtown, and at least can go respond to an issue during a pilot and beyond. So the dumpster pilot we hope to roll out in April. Another reason we were rolling out a little bit later is because we want to hit twilight. We did do the pilot with roll carts during our busiest time, which are fall football games, but spring also has a plethora of events downtown. So we wanted to make sure we hit some of the bigger ones, which twilight for us is a heavy producing event, and it has a lot of challenges because it's so spread out through downtown. So staff recommended making sure the dumpsters were down there during that period of time. After the pilot, we want to give you guys the written update, how it worked, pictures, and then surveys from the businesses and residential units that had to use this system. And then we'll come forward and hopefully it'll be a success and we can provide implementation timeline so that we can roll this out downtown, and then that will also we have code and then policy for how we pick up downtown would have to be changed at that point as well.
How long will the pilot be?
We hope 2 months.
Yeah.
Approximately 2 months. So bar any unforeseen circumstances.
Yeah.
Would it run through AthFest?
AthFest at the end of June. We didn't plan for it, and AthFest, quite frankly, Commissioner, it's not as hard on staff, and it doesn't produce as much because it's concentrated, and it's the opposite end where we have a lot of nooks and crannies down there. Goat Alley, we often can use. It doesn't present some of the challenges that Twilight does. So staff didn't feel it was as important. They felt like they could handle AthFest, dumpsters or no dumpsters.
And then, how much is Chick-fil-A paying for trash pickup downtown?
We have a system in place. The folks and we base these fees on how many pickups we used to give them, which was based on the volume of trash they produced and or recyclables. So downtown, the smallest fee that you have downtown is $32.60. And those are most of our small businesses. That's what they pay per month, and then plus bags. And then Chick-fil-A, Zaxby's, some of the big producers, which would have set out 14 times. That's what that's based on. They pay $161.60 plus bags per month.
What do you mean set out 14 times?
We used to allow them to set out their garbage and recycling so many times per 24-hour period.
Okay.
And so we used to have 12 different rates downtown. Then we reduced it to 8 rates downtown. Now it's reduced to 4 rates downtown. Okay. We had a very robust, when it was started many years ago, they were hoping that the pay-as-you-throw program would be a really big incentive to get people to reduce waste, and that having 12 different levels would work.
Yeah.
It became really cumbersome, and we noticed that really people were basically in 4 levels. So why did we have all this other levels of service? So we kept that because it was a great basis to start on, though, because it gave us an idea of how much volume and how much we should roughly be charging the businesses.
So
but Chick-fil-A is $161.60 a month.
Plus $1 a bag? Are they using city
Plus,
bags?
they're using city bags, yes.
Yeah.
Everybody downtown has to use city bags.
Right.
Recycling bags come at no additional charge, but the trash bags pay for disposal of the waste that you produce.
We wish you well with the pilot.
I know. Fingers crossed for all of us. And if you see anything, or if you come up on the idea, if you see anything, snap a picture, send it to us, positive or negative. We want this to work. Staff really wants it to work because they feel like they could do a much better job at keeping downtown clean and the sidewalks clean if we didn't have garbage bags out there oozing, even for a short period of time.
So this will be a dumpster with EcoStation
No,
pilot,
it
or
will
just
not.
dumpster?
It'll be just dumpster. We could not find any partition that was safe enough without having to drill down into the sidewalk. There's really no partition that we felt comfortable having there, especially with how many bars we have downtown after hours and things that go on and have gone on in our department. We don't want anybody pulling down
Yeah.
a temporary barrier or eco-station
I see.
during the pilot.
So you're trying to figure out how to lock the lid of a dumpster.
Well, no, we know how to lock the lid of a dumpster. We just, or
Well,
try.
yeah, but that's what you need. You need a dumpster lock.
Yeah, maybe a
Yeah.
different kind, so
Yeah,
that we
yeah.
can honor our residential customers
Gotcha,
a little
yeah.
easier.
So do you have a map of where you're going to propose to site
We
these
do,
dumpsters?
and I can send it to you. I apologize, but we do. We actually have a plethora of locations. I'll call it map A and B. We can send both of those to you.
Thank you.
That was.
And none of them are none of them except for one. We would love it. None of them took parking spaces. The only place that we would love to have a parking space, it's not even a parking space now, is right in front of All Goods. All Goods produces a tremendous amount of recycling and garbage, and it's just very difficult. They don't have a good nook or cranny to have but they have a parking space, a striped space right out in front of that bar. That's where they put their garbage anyway, if you go by there. Minus the pilot, because the picture was from the pilot. That was one of the pictures from the pilot where they stacked up their trash in the roll cart. They pile up their trash and recycling right out front in their no parking zone. Yes.
Suki, so especially with the Clayton Street, this is great. I know you had the numbers before about how many pounds of garbage compared to recycling. With the bars, especially like late night bars, like how many of them actually recycle? The ones that use plastic cups and stuff. How much of that actually makes it to our recycling?
They actually, the rate, if you took our rates, they recycle more than any other customer we have as a unit. They have about a 45%, if not, it's been as high as 52% recycling rate. But it's because we have clear bags, Commissioner Denson. So what we can do is we can staff, even if a bar or a restaurant doesn't fully sort their recyclables like they should, but they produce almost 98% recyclables after a certain period of time. It might be labeled trash bag, and they paid for the trash bag, but our staff has been taught that if they know that that's 98% recyclables, it's gonna go into the recycling truck, not the trash truck. So I can't say that they're proactively recycling, but our staff is making sure that material gets recycled.
So half the bars are recycling?
No, downtown. We have about a 42% rate of people that are recycling downtown. That's not just bars. That's
Okay.
everybody.
So it really speaks more to our staff than it does maybe.
No, we have some, well, I have to get kudos. 40 Watt does a great job, but she's done a great job since the get-go. I don't mean to talk about that bar over others, but she literally has staff make sure it's sorted before it goes out. So
great to hear.
there are, and that's not the only example. We honored that bar for going the extra mile with their efforts. You don't see very often where you have staff dedicated at the end of the night to make sure recyclables are in the recycling container and trash is in the trash and that it's properly put out. So we do have people that are, a lot of the daytime businesses do a great job. I mean, daytime, they have the cardboard broken up and put into a larger box. Downtown's just different. At night it's different. You have 3 times as much garbage and trash, and everybody's trying to put it out at the same time at, 2:30 in the morning, and they're competing with Ubers and Lyfts and everything else that's going on downtown. There just doesn't seem as much care to detail for most of the places downtown. But I would be remiss if I said we do have some. Jason at Flanagan's, when he owned Flanagan's, he was a huge supporter of our programs and really tried to take care of that alleyway between the old Jackson Books and Flanagan's. So there aren't isolated incidents. There are some that our staff does it all for them, but we certainly have numerous businesses downtown that do a great job on their own.
Cool, thanks.
Isn't there a policy that requires commercial recycling?
Oh, yes, there is. There is, and we do.
What penalties can be levied against bars that refuse to recycle and are burdening the government to do it for them?
What we can do is get code enforcement involved. The hard thing at night is it would just have to be held over. We would have to hold that material over. It's not insurmountable. We just have to hold or photograph the material. Maybe it's our employees photograph the material so that code enforcement could go back and cite them for not properly sorting that material. And usually it starts with a verbal to try to correct the behavior, then a citation, a verbal warning or a written warning, and then we can give fines up to $1,000. We have done it with multifamilies that chose not to be in compliance with our ordinance. We have not done it downtown, though, to be honest with you.
It troubles me that the citizens of Athens are subsidizing bad behavior downtown and allowing for bar owners not to comply with the law and having to pick up the tab ourselves, not just to have your great staff sort it. I've seen your staff. Your staff works great downtown. I see them every day. But we're also then paying again when we throw it in the landfill. So I would like to hear updates on enforcement actions taken against bar owners, many of whom don't even live in this community, who are shirking their responsibility.
I've written that down.
I mean, so much of the waste is recyclable anyway in a bar, especially at night. It's cups
Downtown,
and
the
cans and
majority.
bottles.
The swizzle sticks, the lemon and the lime, no, but
Yeah.
almost everything else is recyclable. Backwash, we don't particularly care for,
Yeah.
but, you know. So, get a lot of backwash at night sometimes. I don't know why, I don't understand why you pay for a beer and not drink it all the way down, but anyway. Any other questions?
I would say this for the 1,000th time. I don't care what anybody says. Solid waste is the best run department in Athens-Clarke County.
We have the best employees is what we have. We have great employees, so.
And yeah, I'm very, the eco stations that y'all had, some of the pictures up here, having the green roofs and stuff. Yeah, I mean, if we could put those downtown, I think it ends up being, instead of like, you know, things that get in the way, I think it becomes fantastic objects for us to show off our community, so.
In some cases, they even had other components, charging stations. It may not work our downtown, but there, in some communities, I'd be remiss if I didn't tell you they didn't have charging stations, bike, you know, the fixing stations, locking stations for bikes. So there've been some pretty creative partnerships with the trash enclosure and other amenities for a downtown area.
Thank you.
You're welcome.
Thank
You're welcome.
you.
And thank you guys for your flexibility, for allowing me to go last.
Thanks for the cookies.
Yeah, you're welcome.
Yeah.
You're welcome.
Thank you for
You're
the
welcome.
cookies.
And somebody take the rest of the bag. I thought more people would be here tonight.
Missed out on their cookies.
All right, everybody, last thing, you got a copy of the FY20 Mayor and Commission Goals and Objectives. The plan is to memorialize these at our voting meeting first Tuesday in April, just to say this is, you know, this is what we want to set out to accomplish or work on in FY20. You've got sort of the brief version and PowerPoint presentation, the lengthier version that includes some current activities, as well as some sort of adjacent things that staff's working on as well. Wanted to find out if there was any particular area that you wanted to highlight, focus on a little bit differently than you see kind of written here.
Recycling. I could have sworn we talked more about recycling as one of the,
Composting, we did something.
yeah, composting and recycling and livable wages. Working with HCD and ECD.
When you say livable wages, do you mean encourage livable wages throughout the
Encourage
community? I
borders,
see.
yeah. Bring in jobs.
Yeah, I think it might have been, I know this goes down to like how we were doing all the sticky notes, but that on the economic prosperity. And actually, I do like the potential recommended shared prosperity. That's nice, yeah.
It's inconsistent with all the other things y'all are saying.
Right, right. But on that, yeah, I think, because I also had a part on there about focusing on cooperatives and worker-owned businesses, and I think it all got just a little lumped in more than some of the other categories. It's not a big thing on me, but just there was no specific thing on there. The only major question I had was more just like how this. So we have next week's Big Rocks meeting. I guess just a little more clarification on how this is going to play into that meeting. Just for me, my understanding going into it would be.
No, that's an excellent question. So these are what you'd like to see. And let's say that we can't afford all of them. I'll program in what seems to make sense. And so I don't want any individual commissioner that may own something that doesn't see it in there, but it's in full transparency. And so the rest of the process, the mayor may choose when. Big Rocks is where I inform you what I'm seeing in the budget and what we're trying to accomplish with this particular budget. There'll be specific budget goals. And then the way that this process has gone on for years is I get the ability to share that with the commission before I give it to the mayor. Or at least I share what my thoughts were. And then the budget goes to the mayor, and then he changes it, adds things in, takes things out as he sees fit. And then that's represented to y'all, and then you have the last crack at it. And so there's a series of meetings in early May. It usually only takes 3, but we usually program for 2 or 3. And then y'all can toggle some things. But the whole concept of Big Rocks is if you want to make any substantive changes to the budget, it's not on single line items. It's big structural things like pay increases, health insurance or things like that. And so I think you'll appreciate the document you're going to receive. It's very thorough. It explains the what and the why of what's in that particular draft of the budget. So you're able to say, well, you know what, I don't like that. I want to change that. Mm-hmm. And it comes to you ultimately. And Kelly, you're a veteran.
Yeah.
Jerry and Melissa, so from your perspective.
Well, and just kind of even thinking about the experience up to now and, where we may evolve in terms of management of the budget, it'd be helpful for me as soon as possible after Big Rocks, so that's scheduled for next Thursday, I believe. If really by 10th of April or thereabouts, if you have some of those kind of more line item type things as well, please get those to me. What I'd like to see happen is that when we really do have the full budget work sessions, your stuff's already integrated into that, rather than, me presenting something sort of with my head in the ground and then you saying, oh, but Kelly, I would prefer to see, this kind of thing in corrections or this kind of thing in solid waste. To get that early on allows me to bake it in. And so then that first meeting in May, you're essentially seeing our collective budget. Does that help?
Yeah.
That definitely helps a little. Maybe, I like that you put throughout that date of April 10th. Maybe we could formalize that a little bit. I don't know, just to make sure that we all get those things too, because knowing that does help.
Send out a reminder.
Yeah, just
multiple texts.
So, and just to clarify,
Ryan Hope's system.
Just to clarify with Blaine, so basically this document here at this point, like right now tonight, we're just basically saying, yep, that's what we thought, and this is going to be passed on to you to help educate you as you create that first draft that we'll see on Thursday, and then we could, if there was disagreements there on how that was interpreted, we'll be moving those things around on Thursday.
No, I just kind of share with you what this budget has in it, and you take that in, and then I hand it off to the mayor, and it's coming to you ultimately.
Sure.
I'll give you, for instance, and what we'll try to do to be as transparent as possible. I'll take all these statements, and y'all, and I know we're going to continue to work to refine this information, but there's so much.
Yeah.
You've seen some of the current stuff going on. Anything that's new that is relevant to these goals that is in the budget, I will indicate so. To what extent? Let's say, for instance, that I recommend another, for funding, another mental health crisis team in the police department. Okay? I'll call that out. When it comes to tiered approach to fare free transit, I think there's some more discussion that needs to go on with y'all. So to be helpful, it's not in my proposed budget at this point, but I'm going to give you the different levels of costs so that y'all can discuss that. The mayor may decide, you know what, I want to put this level in. But it'll be there in plain sight. And with the thing we need to be mindful of too, and here's my pointy-headed manager coming into the whole thing, that fund balance trend that we've been watching. And so we've got to, there's some goals that, I'd love for us to have a balanced budget. I'd love for us to be mindful of getting our fund balance with a floor that we won't go below and that we'll actually try to build it back over the next few years to get ready for not if, but when the next recession comes. So we don't have to do some of the drastic things that were done last time that have caused us to be in the kind of posture we are now. So anyway, I hope you'll appreciate it, and we can always change the format or add information as you need it.
I just want you to know this fare free transit is very, very concerning to me. It seems to me that we've set a goal, but we don't know how to get there. It seems to me that we know that UGA will not pay us. State law won't let them pay us. They can't give us money. It's not legal. We need, instead of setting a goal of a fare free transit this next year, is we need to figure out how, or if, and when.
Well, and Commissioner Denson did mention a tiered approach.
And
so-
I'm all for, there's some things we can do, like the idea for free fare for us old guys is I think that's something we can do. I don't think that's going to cost us a lot of money.
Well,
But
and we'll show you what that cost is.
Right, but my problem is, I think we need to know that this fare, like, I think Clemson, they no longer have free bus fare.
No, they do. Clemson University is no longer paying into the CAT system, but the CAT system is still free.
Okay. In any case, we need to really understand the economics of this and what's feasible to do before we say this is what we're going to do. Because we're going to we might be setting some expectations that we shouldn't be setting. We need to be more methodical about approaching this. If it can be done, that's great. But what I don't want to see happen is I want to see our bus service improve. I want to see more routes. I want to see more frequent buses. And if we start cutting it like this, then we're liable to lose our bus system, and UGA might be the municipal bus system. I mean, that could happen.
As the largest advocate for this, Jerry, I'm telling you right now, that's not what I'm pushing for. And I'm not at all going to demand that we have something in our budget that we absolutely cannot do. I'm more pragmatic than that. I definitely do not want to sink our transit system. But I think this, as a tiered goal, creates the goal that there is, so we find the way to get there, in which there's a lot of things that we could possibly end up doing, with fees on shared ride services to possible new legislation coming from the state. There's a lot of different ways that we could do this. But I think it's very important that we actually start talking about our long-term goals in these kind of sessions, because if we don't, we're never going to do them. If we're not going to talk about these ambitious things and we're put that goal in front of us, we're never going to get to that goal because we're not even talking about it. So,
Thinking, and I'll get you in just a second, Melissa, but kind of thinking broadly about sort of tying these concepts together, we might look at some language that suggests something like, using our transit system to support the breadth of our population, rather than, in title calling out fare-free transit, and may even be explicit in saying, working with state, federal, and local partners in an evolving environment, which is what we're in right now. There's this, Tim and I were emailing about this earlier today. There's a bill that's passed the House already that's in front of the Senate that would provide some state-level support for transit that just doesn't exist right now at all. I think, Tim, you just mentioned that there, in this draft, are some kind of fees on ride sharing that could feed into transit. So we are in a little bit of a new environment and don't know what that's going to produce and what that could mean in terms of outcomes on a local level here. So I'm certainly comfortable kind of putting some different language together that still gets at the idea that we're really looking at, again, the breadth of needs that we have, in some cases for different components of the population.
Can I say something? I would like to be filled in on any sort of discussions that have been had with the University of Georgia regarding transit collaboration and movement towards a fare-free transit system.
Well,
yeah, I mean
any talks? Have any talks occurred?
There have been some informal discussions. That's where I learned that the state law will not allow them to pay us. It's considered a gratuity. If we have free bus service, then we have free bus service, and UGA is not going to pay us.
Well, I think
and we lose the federal money too.
Well, I'm not. I would need to get more information on that, Commissioner.
Sure. Well, that's why I say we need to look at feasibility before we.
I mean, because the government would be providing a service. They wouldn't just be giving us money for nothing. So I would just need to see that. If that is going to be their position, I would just.
Can ride for free.
That's a service that we're providing.
But it's free.
Their services.
It's free.
I mean, I'm not going to debate you as if you were the attorney for UGA, but,
I'm just telling you what.
those are the ideas I'd like to see fleshed out. If they are going to make a gratuitous claim like that, then, we should move on, but let's figure it out. And I'd say, keep it as a goal, put it out there.
I'll certainly engage and see if they'd like to make a kind of formal proviso. Melissa?
Yeah, I've got a couple things. I'm definitely interested in finding new revenue sources, whether it's through, coming up with fees that would help cover transit, whether it's, additional tag fees or, it's so late, y'all, I'm losing my mind. Uber and Lyft charges, also Airbnb charges that possibly could be funneled into housing funds. And maybe we do need to start a conversation with the university about payment in lieu of taxes. It's very common in other university cities across the nation to cover transit fees, fire fees, transportation, road surfacing, all that stuff. And also offset the student market that impact that it's had on our housing. And also, Mariah and Ovita and I have been meeting with some residents of East Athens, and we'll be talking to Kelly real soon about some asks for that community that fit in within our goals. That's a part of town that's kind of been overlooked, and we think that there are some, real specific things that those residents would like to see, especially in the wake of the settlement that was announced last week. That community's pretty injured right now, and I feel like they deserve a little bit of restitution. And we've put a lot of effort into the West Broad corridor, and maybe we can start looking towards East Athens. And we have a really nice police substation over there that's pretty much vacant, extremely underutilized. We're talking about all these new criminal justice initiatives that are more restorative justice and preventative. So we're going to be we'll be coming to Kelly with a broader conversation about some specific things we can look to in that particular neighborhood.
Anything else that you want to highlight? Yeah, Tim.
I guess just one thing, I mainly put this out there because of the saying that we might have a discussion with the university, even somewhat informal, about this stuff. And I definitely agree with looking into payment in lieu of taxes. And also, if we're going to have that conversation, I'd like to have the conversation be part of that, be a fire service fee for the university. That is a great expense that we have, that we provide to the university. And I know that we've had to change a lot of our infrastructure we have to actually service the buildings and the population that they bring here. So, that's another way I think that we could be talking about some revenue changes if we're going to have that discussion with the university now.
I have one question, just for clarification. So one of the things that was said was re-examine the ACCPD pay plan. Did tonight help address that, or is there something further that y'all want to do with that?
I have a question. I've had some constituents come up to me in the past couple of days concerned about police recruitment and understaffing. Any updates on that, or how we're looking at with size of force and any progress there?
Sure. Well, I was supposed to have an update with the chief on Monday, but because of the shooting, we did not get together. And we talk about that each time we have our monthly update. I do know up until the hiring of Chief Spruill, the beginning of February, the big issue, as y'all know, was retention, and that had at least slowed down. And we had folks in the academy, and I think one group came out towards the end of the year, and we had another group coming out, mid-February. But I will email the group the specific numbers of where we are as far as strength of force.
As far as the pay plan is concerned, you could probably tell that someone is whispering in my ear about how unhappy they say the police officers are about the pay plan, that it didn't achieve anything. Something like 86% of the police force are paid below the midpoint. I don't know if that's significant or not, but it makes you wonder. So I just wonder, maybe it does need to be looked at, or we at least need to understand their perceptions and try to address them.
Well, we certainly need to have some conversations with them. As far as the midpoint's concerned, that's sort of the range that you would travel throughout that pay grade over 20 years, perhaps.
Yeah, well.
And when you raise the minimums
apparently they're not. they're not traveling through it. It's.
Well, we've got we've raised
Yeah.
new minimums, and so when you raise the minimum, midpoint goes up as well.
Well, as I
so-
said, it's at least we at least have a perception problem.
Okay.
And we need to determine how we address that. Is there something needs to be fixed, or does something need to be explained?
Understood.
Yeah.
Thank you.
Blaine, on that, I'm wondering, and which I know HR said that they would get it, but like, if I could see what that new safety pay grade scale looks like, since it wasn't in the documents we have, I would, if we had that, and then maybe a little bit more information of what Jerry's talking about, like how many of those people were below there also, maybe some of that specific information, like 78% of employees received an adjustment. How many of those on that specific safety scale received it? It's a little more information specifically about that scale, because I feel like we got a lot of information on the unified scale.
Sure. So that same type of information just for the public safety panel.
That possibly would suffice for me rather than having to, but
Okay.
I'd like to see it first.
But I understand what you're saying too, Commissioner Neesmith.
All right. Thank you, everybody.